Here it is. Right over here. Are you in opposition, against, or for? He has to sign in. Okay, right there, sir. Um, Eve Eninger. Eve Eninger. Eve Eninger, would you please come over to the appearance form desk? Yes, yes. So you want to have a seat? Yeah, right here. He'll see you. He knows you're there. Are you here on? Here you go, sir. Okay, we'll be starting shortly. All right, if there's anyone requesting a continuance, if anyone is requesting a continuance, would you stand in the line where Council Borstein is standing? Raise your hand. Okay, you can stand in back of Council Borstein, and now Council Kupiec. It had to be done.
You want me to help organize them?
No, I appreciate it though. I got it. What I have been doing is putting all the lawyers together,
Together.
yeah.
So I put Nick's together.
Perfect.
We should put all
Thank you.
hers.
Perfect. I appreciate it. Thank you, Council.
What's up?
That's
Hi.
I'm so lost here. Okay, good morning. Welcome to the June 12th, 2026 meeting of the Zoning Board of Appeals. I'm Helen Schiller, the acting chair of the ZBA. I'd like to establish a quorum. Commissioner Pascal,
Present.
Commissioner Hobbs,
Present.
Commissioner Staley,
Present.
Commissioner Soto.
Present.
I'm here, a quorum is established. I move to approve the minutes from last month's May 15, 2026 meeting. Commissioner Soto seconds, Commissioner Pascal, sorry, Gianni.
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley.
Yes.
Commissioner Soto.
Yes.
I vote yes, the agenda is approved, the minutes are approved. I move that we approve the agenda for this meeting. Commissioner Soto seconds. Commissioner Gianni,
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley.
Yes.
Commissioner Soto.
Yes.
I vote yes, the minutes are approved. Before we proceed with the continuances and withdrawals, I'd like to hand the mic over to Commissioner Staley for a personal statement.
Thank you, Commissioner Chair. I am very sad to announce that this will be my last Zoning Board of Appeals meeting. I will be tendering my resignation for personal reasons after following this meeting. I want to thank all of the attorneys and the applicants who have come before us and exhibited just such professionalism. And I'm hopeful that my tenure has contributed a little bit to the city, and I want to extend a personal thanks to my fellow commissioners who it's been a wonderful experience working with all of you, and specifically to the DPD staff who work tirelessly day in and day out to make all of this happen and in the interest and furtherance of such important things for the city. And a specific thank you as well to the Department of Law, who has always given us such sound advice and guidance throughout this process. And it's just been a pleasure serving on this board, and I want to thank everyone for the opportunity, and including the mayor. And with that, I'm looking forward to
This meeting.
my last meeting.
Well, thank you. Thank you, Commissioner Staley. It's been a pleasure to serve with you. I know we came on pretty much at the same time, although you got one meeting ahead of me. And it's been great, and I'm sorry to see you go, but good luck.
Thank you.
I think that it just sounds like it's a very good, what you're doing is a great opportunity, and I wish you all the best.
Thank you so much.
All right, we ready?
Ready.
Okay, we will take continuances.
Thank you. Madam Chair, Scott Borstein from the Law Houses, Neil and Leroy here on behalf of the Public Building Commission and Department of Family Services and Support. We are asking for a continuance for our cases on page 3. It's for a proposed senior center. I think it's 21626S. A special use we have filed, but we have since discovered along with the city that we need some additional variations for the application. And there was also some design issues that we have worked out with the city, but the variation applications won't be ready. So we would ask for a 1-month continuance.
Okay, so we will continue this matter to July 17th, 9 a.m. call, and no further notice will be given.
Thank you so much. Commissioner Staley, thank you for your service.
Yeah. Okay, sorry, an additional notice, thank you.
Oh, yeah, written
For
notice.
any of additional variations or additions to the application, a new notice will go out. Thank you.
Thank you.
Madam Chairman, members of the board, Mark Kupiec for the applicant. Bottom of page 4, 22426Z, 7807 Southeast End Avenue. Madam Chairman, this property is in the 8th Ward, and yesterday Alderman Harris called me and asked me to continue the case. I think there was some confusion about the date of the hearing, but she asked me to continue it. I have got an appointment to meet with her on Tuesday.
Okay, so we will continue this, I don't remember the date, to to August 21st, 9 a.m. call. No further notice will be given.
Thank you.
Thank you. Good morning, members of the commission. My name is Lenny Asaro. I'm an attorney at Taft, Stettinius, and Hollister, and I am here with regards to the last item on page 6. The applicant is 7508 Property LLC. Before I request the continuance, I also want to just second the comments that were made about Commissioner Staley. Appreciate your professionalism, appreciate your diligence, attorney to attorney, practitioner to practitioner. Thank you for your service. Really appreciate it. Thank you.
Alderman, are you here on this item?
I just had some questions after he say what he, for the case.
Regarding the continuance?
Yes.
What are your, no, why don't you ask?
Yeah.
What are your issues regarding the continuance?
No. This fine today, but
Oh,
is it go?
that's what I'm questioning. So
no,
you
I-
have any problem with the continuance?
No, I just want to know, is this going to be the last one?
This is, okay,
Yeah.
so this should be the last one. The question is, I believe that the reason for the request had to do with the FOIA request, is that correct?
That is correct. And
So
if I might,
To
Chair-
be safe.
Yeah.
Just in terms of the
Sure.
timing, do you want to have this go to July or to August?
well, I'd actually
We're not
like-
going to do another continuance.
Well, that's fine. I'd like it to go to July, but I just want to express on the record, because I think
Yeah.
this is important. We don't have any control over whether the FOIA officer responds and provides the documents. So,
Okay.
and if I'm allowed to just basically read into the record, it's very short. We are requesting a continuance, and in support of the request, the following is the good cause, which I believe is the standard for deciding it. On May 28, 2026, pursuant to the Illinois Freedom of Information Act and Section 1.5 of the ZBA Rules of Procedure, I emailed a written FOIA request to Mr. Victor Reza. On May 29, promptly, Mr. Reza, via email, advised me to submit the FOIA request to the DPD FOIA officer. That officer's staff person is LaShonda Morgan. On June 4th, 2026, via email, Ms. Morgan provided me with the ZBA April 17, 2026 meeting minutes regarding the application. The minutes show that the matter was continued to June 12, 2026 today. No other documents were provided in response to the FOIA request.
Okay.
I'm tendering to the chairperson if I can. This is a copy of the FOIA request. There's 10 numbered requests with a few different subparts. No documents were produced in response to that FOIA request, and there was no statement indicating whether or not there's been a search of the documents, and if there has been, why the documents are not being disclosed and released. Therefore, I don't have control, or if the FOIA officer complies with the act or not. I would hope that they would, because I don't really want to, on behalf
Okay,
of my
so
client,
why
take
don't-
any action.
Why don't we do this? And Alderman, let me know if this makes sense to you. And to the staff, let me know if we can actually do this. But what I would like to do, since FOIA requests do have a timeline on when they're supposed to
do.
be responded to, let's go ahead and schedule this for the next meeting in July. But if you haven't gotten the request, I need to, and therefore need it continued, the alderman and the staff need to be informed at least a week in advance. Because otherwise, they're going to be down here and we don't want to repeat what happened at the last meeting when there were a lot of people that came. We want to encourage people to be able to participate, but we also want to make sure you have your full record and all the evidence that you need to come here.
For the
So
record,
I don't
Chairman-
want to prolong it as
Right.
long as, I don't want to prolong it beyond the date, and it's reasonable that you should have it in
you.
July. But if you don't, we need at least a week's notice so that, to the staff and to the Alderman's office, just to let us know that you'll be asking, that you haven't received it and you will be asking for another continuance, because at that point, we will go to August.
Understood. And just
Okay?
for the record,
we
Your
need
Honor,
to Then at the next meeting to request the continuance if you need to do that.
I will follow your instructions to the T. But just for the record, Your Honor, when I submitted this FOIA request originally, I'm not under any obligation to actually provide courtesy copies to anybody. I provided a courtesy copy to Alderman Hall. And then when I sent follow-ups to the FOIA officer, I copied Alderman Hall. Before today's hearing, I even asked, I sent an email to Alderman Hall and indicated, since we don't have the documents, and since I know that there are people that want to participate, out of respect for the objectors who want to participate and the supporters, I asked whether or not we would have an agreement for a continuance. And I realized that it was in the last 48 hours, but we have been.
So I
providing courtesy
appreciate that.
copies. Thank you.
And if there's a change that occurs, then you
Yes.
can have that conversation with the alderman. And if you and the alderman agree to proceed or not to proceed based on what the status is at that time,
Thank you.
I'm sure that we can accommodate that since you will be on the agenda for July.
Thank you.
But if there has to be a continuance, I don't want to, I don't want to be down here with all these people from the community ready to testify at the last minute to find out you're asking for another one. That's why I'm asking for this to occur first.
I'll follow your instructions to the T. Thank you, Chairwoman.
Alderman Hall, does that work for you?
Oh, that's perfect. And congratulations on your next chapter. You definitely were a light for all of us. Appreciate you.
Thank you, Alderman.
Good morning.
Good morning, Chairman. Nick Fatikas for the record on page 6, the top of page 6, it starts with item 23126Z, 12726S, 12826Z, 12926Z, 13026Z. We've been actually working with the local community organization as well as Alderman Walter Red Burnett on a possible redesign of the proposal. We'd like to preserve the filings, but if we can get a 3-month continuance into September, we think that'll give us enough time to work through the community process. We may end up withdrawing the application if that other process is successful. If not, we'd like to have these on file, remain on file.
Okay, so we're going to continue this to the September 18th, 9 a.m. call. And there may or may not be further notice given based on your status.
If anything
you
changes,
change it.
there'll be notice. If not, then none.
Okay, fine.
Thank you.
Are there any other requests for continuances or withdrawals? I think that I'm going to,
Chair, on behalf of the applicant, on page 1, 20526S, 11946 South Halsted, there are still some outstanding plans that need to be submitted to DPD. So if we can continue that case to August.
okay, so 205-26-S will be continued to August 21st meeting, and no further notice will be given. And just so that there's, what I would like to do is just go ahead right now and do the motion to approve the continuances that we've just heard, and then we don't have to do that again. So I move that we approve the continuances 205-26S, 216-26S, 224-26Z, 231-26Z, 127-26S, 128-26Z, 129-26Z, 130-26Z, 116-26S, to the stated dates and times that have been previously stated. Commissioner Soto seconds, Commissioner Gianni,
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley,
Yes.
Commissioner Soto.
Yes.
I vote yes, the matter is approved. Okay, so go ahead. Continue. The matters are continued. Thank you. The matters are continued, not approved. Okay, Victor, you're on.
Chair, we're going to go slightly out of order on page 5, case 22526Z, 1643 North Hudson.
This is not a special use. You, Victor, you can take all of it, everything before the two, right, for the land, before, right, what? No, after this, I do. The special use. What about what Fernando needed?
Well, Fernando's gonna leave.
Oh, he's gonna, okay. Morning.
Good morning.
Okay, so applicant, correct? Raise your right hand. Do you swear that your testimony before us today will be true and accurate?
I do.
And do you swear that the application is submitted continues to be true and accurate? Okay, great, thank you. Can you just give us your name and address?
Antonio Melito, 1643 North Hudson.
Great.
60614.
Great, thank you. All right, Counselor, you're.
Very briefly, my name is Tom Moore. Mr. Melito grew up in the building next door where his mother still lives. He raised his family in this building, which they've owned since the 90s. He went to school across the street, and he had a fully permitted renovation of this building for his later years. And there were a couple of non-conforming things involving the garage and a deck, which these variances will bring into compliance. We have a support of we are aware of no opposition, and the alderman has sent a letter of support, and we'd request your support as well.
Okay. All right. Anything from the commissioners? All right, in that case, I move that this matter be approved. Commissioner Soto seconds, Commissioner Gianni?
Yes.
Commissioner Hobbs?
Yes.
Commissioner Staley?
Yes.
Commissioner Soto?
Yes.
I vote yes, the matter is approved.
Thank you very much.
Thank you very much.
Welcome.
One, case 185, 2686, 73 West Parkwood.
Oh, this goes with, whatever. That went with, yes. Can I have everybody come down, the objectors as well as the applicant? And is the zoning administrator here? Oh, there he is. Second, thank you. I know, but there's some space. I mean, we can. I think we got this. So the order is with the. Yep. And. This is all. To me, stay. Before. Which is the rules of. No, I understand. Extension here. Yeah, okay, I don't.
I think right here in the front.
Because I mean,
Yeah.
the way that like anytime.
Actually, back here, can you hand him back here? Hand him to me back here and then I'll.
First impressions,
If we want to put the picture up, so they're behind us.
Is the difference is.
Yeah, so
What
I
he
think
can
that's
say
the way-
was what it was. Right, it was in the record though, from.
So if that's.
I don't know if it's in the record. It's in the record from the. Otherwise. Because he hasn't done to respond yet.
Got it. So I think.
We need to let him, yeah, and I can ask. Okay, I think, can I have everyone who intends to testify to raise your right hand? Everyone, all applicants and witnesses, and interested parties. Do you swear that your testimony before us today will be true and accurate? Okay. And to the applicant, Do you swear that the application as submitted, the application as submitted continues to be true and accurate? Where is the applicant? I need you to swear that the application as submitted continues to be true and accurate. Okay, thank you. Okay, you want to, Counselor G, can you introduce your witnesses and your applicant?
Good morning. My name is Mary Eileen Wells. I'm an attorney at Miller Shackman, and I'm here with co-counsel Bridget O'Keefe. And we represent Lisa Barron, who is appealing the administrative adjustment granted by the zoning administrator to 673 West Wrightwood. And I also have here with me Jean Dufresne, an architect who will also be testifying.
Okay, so can you present, I guess you should give us an overview.
Chairperson, I'd like to start actually with an objection, if I may. We sent a letter yesterday objecting to the participation of Wrightwood number 3 as an interested party. Wrightwood number 3 is the owner and developer of 673 West Wrightwood, which applied for the administrative adjustment. It's not a property owner that is abutting the subject property. It is the owner of the subject property, and they had the opportunity to present their evidence and their testimony when they applied for this administrative adjustment. They don't meet the definition of an interested party under the ZBA rules of procedure, and they've already had the opportunity, and to the extent that they want to inject anything new, which is what they did in their June 9th submission, it's irrelevant. They don't want you to look at the record that was before the administrator. We're here asking you to take a very close look at that. And they're asking you to consider new irrelevant issues. So we ask that they not be allowed to testify or submit any new evidence. If they are, that they can't testify or submit any evidence that is new. And if they're allowed to put on that testimony, Ms. Barron is entitled to show why what they are attempting to admit is a mischaracterization of what's happening. And inaccurate. And we're prepared to do that, but we need to be given an opportunity if they're allowed to introduce that additional evidence.
Well, you've said several things. So what I will say is that we will be considering the all the parties that are affected by this and are affected by this by proximity, as well as by the very fact that they've all been engaged in some part of the administrative process. And are affected to be able to testify as interested parties. However, in every instance, it's my understanding that given that there is a record that we are specifically addressing, and that both for the applicant and for the interested parties, we're going to focus on that narrow definition, and we are going to rely, and will need to rely in large measure, on the application materials as submitted and the materials and information that we will get from the administrator with regards to his consideration, his process for making a decision, consideration. So we will rule on these individuals, or we will proceed and limit the discussion as necessary according to what I've just stated. Oh, wait a minute. So to be clear, I'm going to overrule the objection. I'm going to allow testimony to proceed, and I'm going to, though, however, when appropriate, limit that testimony based on the definition I just gave. Okay. So can we proceed? So how we're going to proceed is we're going to have you present your case, then we're going to go directly to the administrator, who will be able to respond. And from that point on, we will be able to see exactly how we're going to proceed with the interested parties.
And if I can ask before beginning, we made a copy of the full administrative packet, the one that was submitted by the zoning administrator on June 1st. But we added page numbers to the bottom, so it'd be easier for everyone to refer to the packet. If I may ask for these to be
Sure.
passed out.
You have one? Do you have there?
We're here today because Ms. Barron is appealing the administrative adjustment that was granted to 673 West Wrightwood, which I'll call either the museum property or the subject property today. That administrative adjustment reduced the west side setback, which is adjacent to Ms. Barron's property, by just over 2 feet, from about 4 feet, 7 3/8 to 2.5 feet. And as we'll discuss today, those 25 inches matter a lot. Ms. Barron is the owner of the third floor unit at 675 West Wrightwood. You can see it in that picture up there in that demonstrative exhibit. It's that top unit there in the upper left-hand corner. Now, under the zoning ordinance, an appeal can be sustained if the zoning administrator has erred. Here, the zoning administrator erred both procedurally and substantively. And we recognize that the zoning ordinance requires that the board grant the zoning administrator's decision a presumption of correctness, and that Ms. Barron, she's the appellant, she bears the burden of persuasion. We're prepared to meet that burden here today. But I want to note something important. That presumption of correctness assumes that the applicant has provided and the zoning administrator has relied upon complete and accurate information in reaching the determination. That did not happen here. As you'll hear from Mr. Dufresne and from Ms. Barron, the information provided to the zoning administrator was misleading, incomplete, and inaccurate. That's why the zoning administrator erred in granting this administrative adjustment. I want to emphasize the unique nature of this case to start with. So if you look at this exhibit right here, on the left, as I said, the top left-hand corner is a picture of 675 West Wrightwood, where Ms. Barron lives, next to one of the two buildings, the two homes that Wrightwood number 3, the applicant demolished recently. And on the right is a rendering that the applicant has submitted to the city with one of its building permit applications, showing the building that they plan to construct. And on the bottom, you can see what the block looked like before the demolition of the two homes last summer. As you can see, Wrightwood number 3 is planning to build a hulking building on this residential street. It's replaced the two homes from the 1880s with this 65-foot tall building. Now, if that were residential, that would be a 6-story residential building, but it's not residential. It has a planned civic use. It's going to be a museum. So that means that they're allowed to build a 65-foot tall building. They're also reducing the front setback from 30 feet to 15 feet from where the now demolished homes used to sit, and also where most of the buildings on Wrightwood sit. Most of them have a 30-foot setback. This new building will have 15 feet. Now, as I said, they're allowed to build this. The zoning code allows the civic use to have this tall height, and it's allowed to have this use without any sort of zoning process. So the hearing that we're having today and this administrative adjustment, this is the only zoning process for this building that will greatly change the character of this block. And because there were no community meetings on this, Ms. Barron had never seen the current plans for this building until after she received the notice of the administrative adjustment and went to the zoning office to see them. And as you'll hear, she was in the process of trying to get the information to put in a fulsome objection when the zoning administrator abruptly granted the approval. That's why this hearing is so important. Ms. Barron must be given the process that she is due. And she appreciates the time and attention that you are giving this matter. And hopefully brief presentation today. We'll call 2 witnesses, as I said, Mr. Dufresne and Ms. Barron. But first, I briefly want to go over the law because that's what this is about. In front of me, there are 2 boards, I believe. I can't see them. Oh, no. Actually, they're behind me. Actually, I can fix it. Can you pull it right here? Okay. So we have on these 2 boards the relevant provisions of the municipal code, the zoning ordinance that govern here. And as you well know, this isn't guidance, this isn't suggestion, this is binding law enacted by City Council. So first in 1713/1001, this discusses what the administrative adjustments are intended to do. And you'll note here that it is to allow development that is more in keeping with the character of the neighborhood when it's necessary to address unusual development conditions and that it won't adversely affect the neighboring properties or the neighborhood. Now, the authority of the administrator is also limited in 1713-1003I. Here there are two limitations on the zoning administrator's authority. First, there's the predominance of the block issue. You have to establish that the reduction would be, would match the predominant yard depth of existing buildings on the block, and that's the predominance of the block. The second factor, the second requirement is that the administrative adjustment may be approved only when all of the criteria in 13-1007B are met. So the approval can only be granted if all of those criteria are met. Thank you. Now turning to 1713-1007B, here are those criteria. And again, importantly, the adjustment can be granted only upon determining that all of the following. This isn't an either or. All three of these have to be met. And the first one is that the administrative adjustment is consistent with the zoning ordinance. The second one is that it has to be eliminating an unnecessary inconvenience to the applicant. And that it won't have any appreciable adverse impact on the health, safety, general welfare of surrounding property owners or the general public. And third and finally, any adverse impacts resulting from the adjustment have to be mitigated to the maximum extent feasible. So all of these factors have to be met. And today our discussion will be guided by all of these factors. And actually keep this right back here for a second. Before calling Mr. Dufresne, though, I would ask for one housekeeping matter. Ms. Barron has submitted an application and a supplement to that application with exhibits 1 through 17. And we'd asked to have those admitted into evidence as a group rather than having to do it individually in order to save time. We have the exhibit books that we can hand up. Oh, you excuse me, I already have them.
Okay, that would be, okay, yeah, we'll admit those.
Okay, thank you. Okay, so I'd like to call Mr. Dufresne.
I
to
do,
witness.
I do want to make it clear that as admitting them, I'm going to allow any response to them or specific response to them or rebuttal, if you will, by both the zoning administrator, but also by the interested parties when we get to that. So it's a package here.
Thanks, great. So I'd like to call Mr. Jean Dufresne as a witness. Mr. Dufresne, can you briefly describe your professional background?
Sure. I'm licensed architect in the state of Illinois. Been practicing for 28 years in Chicago, mostly in the city of Chicago.
I'm handing you what's been previously marked as Exhibit 18. Can you tell me what this is?
My resume?
Okay, is this an accurate summary of your professional background and qualifications?
Yes.
Chairperson Schiller, if I can ask to have these exhibits, which is Mr. Dufresne's resume, provided to the board. And then I'd also ask to have it moved into evidence.
I think we can go ahead and stipulate to Mr. Dufresne's expertise in the field.
Appreciate it.
Thank you.
Okay. Have you been involved in administrative adjustments in the past?
Yes.
How many?
25 to 50 over the last 28 years.
Have you ever testified on behalf of an objector?
No.
Okay. Now, what was your scope of your assignment related to this appeal?
To review the material that was submitted for the administrative adjustment and review them against the criteria for the administrative adjustment.
And what did you do to prepare for your testimony today?
Review the application. I walked the block. I also just reviewed the zoning ordinance against it.
Based on your review of the materials submitted to the administrator, your walk of the block and the zoning ordinance, did you reach an opinion as to whether the requested administrative adjustment met the required criteria of the zoning ordinance?
I did.
And what is that opinion?
I don't believe it does.
Let's walk through the basis of that opinion, and we will walk through the ordinance as we did before. So starting with the intent of the ordinance, with 17-13-1001A, it says that the administrative adjustment is supposed to be in keeping with the established character of the neighborhood. Do you believe that this adjustment is consistent with that requirement?
I don't.
Why not?
The character of the neighborhood is not solely a setback. It's a combination of elements that includes anything from massing, architecture, height, use, and all of those components grouped together. And this is an anomaly and unique in all of those aspects.
Now, looking at the next requirement, which I believe is in front of me, it's 17-13-1001C. In your expert opinion, is the requested administrative adjustment necessary to address any unusual development conditions?
No, there's nothing sort of, the lot is not a unique shape. If anything, it's bigger than usual. It's deeper than usual. There's nothing sort of, there's no added constraints to this particular lot for development.
Now, 17-13-1001C also says that the administrative adjustment is intended to provide limited flexibility when it won't adversely affect nearby properties or neighborhood character. In your opinion, is the requested adjustment consistent with that requirement?
No.
Why not?
It's adversely affecting, I believe, one property, the property to the west, and providing a tremendous amount of relief to an empty lot on the east. So it's not consistent with that.
And can you tell us a little bit about the property to the west, Ms. Barron's building?
Yeah, so it's late 1800 property. It's 3.5 stories tall. It has a shorter side yard, which expands a little bit as it goes back. The majority of the windows for the units, which is typical of a 3.5 story building in Chicago, are all on one side, circulation being on the other. So most of our windows faced east. So having this building very, very close to it does pose it's a detriment to her property or any of the units that are on that side.
Now, if you look at the packet in front of you, there is the application narrative. Let me see. Lost my copy of it. We can look at it together.
Sure.
Thank you. Just 1 second. I can tell everybody the page number. Apologies. Okay, well, Ms. O'Keefe, can you look at that page number? Okay. And I'll tell you what the application narrative says, and then we'll direct you to that page rather than holding you up. The application narrative submitted by Wrightwood number 3 says that the proposed condition will actually increase the setback that historically existed along the west side of the subject property. And this is one of the bases for the request. What is your opinion of that statement?
I think it's misleading simply because if you look at the exhibit that's posted up there, you can see the 2 flat, which is the more orange building to the left. The increase that they're talking about is 15/16 of an inch. So the new building technically is proposed to be less, just shy of an inch further away than Mrs. Barron's building. The big difference, to be contextual here, is we're talking about a building that was 2.5 stories tall, about half the depth of the proposed building, where it's now going to be replaced with a 65 foot tall building that will be 15 feet closer to the property line on the front and extend past her building towards the back. So an inch on a 2.5 story building is much different than an inch on a 65 foot building with that deep of a building. So there's context to be considered here.
What is the average front setback on this block?
On that side of the street, the average setback is about 30 feet on the front.
Now, is that reflected on the 80-acre map?
So the 80-acre map does have a setback that's outlined as 30 feet. There's two exceptions on the block. There's a courtyard building to the west, and there's a what used to be a residential building to the east, both of which predate the zoning ordinance. Everything else on the block is within that 30-foot setback range. This particular proposed building reduces that by half.
Now let's look at 1713-1003I. This is the requirement related to the predominant yard depth existing on the block. Is there anything in the zoning administrator's materials regarding the predominant yard depth of existing buildings on the block?
Yes, there's a block diagram. So this is that right here is in the submission.
At this time,
The packet.
yeah, it's in the packet. And then at this time, I have what we've marked as Exhibit 19. And I'll represent to the board that this takes some of the photos, the parts of this site survey block that was submitted by Right With 3 to the administrator, and blows them up so it's actually legible. If I can ask to have this admitted into evidence and provided to the board.
It's the same.
The only
thing.
difference is that it's been enlarged?
Yeah.
Okay.
It is a selection of them enlarged.
Yeah.
This is just so that they can actually see the picture and
Yeah.
read the words underneath it.
You're not, this isn't anything new. It's what we already have.
Correct. It's just a
Right.
version that you can read.
Okay, so you're not actually admitting new evidence.
Can I proceed?
Yes, go ahead.
Did you review the site block submitted by the applicant here?
I did.
In your expert opinion, is the site block survey accurate?
It is not.
Why not?
So if you look just at cursory review, I'll give you a couple of examples. If you look at this particular property that's in the top right, which is 635 to 37 West Right.
And that's page number 1 of Exhibit 19?
Yes.
Okay.
On the application and on this diagram, which right underneath, it states that both side yards, east and west, are 0 inches. And then if you look at the diagram right below it, it represents the building right here. You can see there's a gap on both sides. So that led me to just street view the building, and then I also walk the block. There's a minimum of at least 3 feet on both sides of that building currently. So the data on this particular building is inaccurate. Then I looked at 639, which is right next to it.
That's on page 2 of Exhibit 19?
Yes. So that lists the east as 1'9" and the west at 0. The building, as you can see from the image, doesn't have a front door. There's a unit with a sort of a patio pit on the garden level, and then balconies on every other floor. That's because the side entry of the building is on the east side. Per code, at a minimum, this new construction building would require about 44 inches or 3'8" on that east side, not 1'9". I noticed that on the block, my block walk as well. So that's inaccurate. The following building, 641, is listed as having 0 side yard on both sides. This building also has a side entry on the east side. It is also 3'8". There's a little bit of a setback on the west as well, so that's also inaccurate. I then looked at a couple of the other buildings on Deming. There's 632, 618, and 612, which are all in the packet, are listed as having side yards that are less than 2 feet. All 3 of these buildings have a driveway leading to the back garage on the property, which at a minimum needs to be at least 9 foot, if not 10. So that was inaccurate. And then there's another building on the block, or a property on the block, 622 West Deming,
That's page 6 of the.
which is right
Exhibit
here. Yeah. That property is illustrated as having a building on it, and also dimensioned on here as a front yard. There's no building there. It was demolished in 2012.
So just for clarity, and
Yeah.
when you were looking at the buildings, were you comparing it to the actual property lines?
Yes.
You know,
So the information that is on here, I don't know where this data was pulled. I'm looking at a building and walking it and seeing it.
that's not what I'm asking.
Okay.
The actual site of each property
Mhm.
is the site where the property is on is how the side yards are determined.
Correct.
So my question is, for all of these, and from what you're saying, I understand you're saying there's so much space
Mhm.
between the buildings. But where is the property line and which property? Is there a property that is that is within a zero or whatever has been stated here, as a sideline,
So
as
you're-
as a side yard? You know what I'm
And
saying?
you're asking me, in my opinion, are there some properties on
I'm
the
asking
block
you
with a zero side yard?
For your method of work.
Okay.
Did you compare, for each of the properties that you've given us information and identified and saying it's different, did you actually look at that as though it was sitting on its actual property? So that it. could you only say
Effectively,
it more
she's
clearly?
asking if you pulled the survey lines and
I-
did a direct comparison.
Property lines are invisible when you're walking. You can't see them. You're basing them on, if it's an old building.
Right, no, I understand that. So I've
Okay.
just been wondering if that was included because that means something to us in terms of understanding this.
100%. And that's why, as I was walking, especially, let's say 635, 639, and 641 are new construction buildings were built after 1994. So well within the existence of the zoning ordinance. So they were built on their own property. They would not overstep a property line. So the assumption is.
I'm looking at side yards.
Yeah, and that's what I'm talking about. All of those properties clearly have their fences that delineate their property edges. They would have been built within the bounds of their properties, and they clearly have components and elements that are well above what is listed on this diagram. The point I'm trying to make on this diagram is the inaccuracy of the information that the zoning administrator was basically basing this on. All that they could do and can do is base it off of the information that is provided. I'm simply pointing to the fact that they unfortunately were provided with inaccurate information.
And I'm just trying to understand the method of work.
Totally understand. The confusion also is typically these block diagrams will also have a summary of what all the data is, a list of the quantities of lots so that determination of predominance can also be established so that the administrator is not the one counting. Someone did the math for them to show that it's 51% or more of these lots that have this condition. That's not also provided on here. I was, again, surprised to see that there's properties that are illustrated that haven't existed on this block for over a decade.
And just also as a, just for clarity, the first three properties are properties that are adjacent to one another. Is that correct? All right. And then for 612 and 618, those properties are not adjacent to one another, are they?
612 and 618, I believe, are,
Okay.
yeah, I'll have to, they're right over here on Deming, just a little east of the St. Clements.
So in your opinion, the determination that the requested adjustment met the predominance of the block was based on inaccurate information?
Correct.
Let's move on to the other factors. We're going to talk about the general requirements of 1713-1003I. And this is the one, again, that requires that the setback meet all of the criteria of 1713-1007B. And so we will walk through those factors right now. I'll just prop this up between us if you want to.
Sure.
I can put it on your
Oh,
chair.
there we go.
We will make do with this interesting setup.
There we go.
Okay, so let's walk through these first ones here. The first one, again, I just want to emphasize, all three of these need to be met. And the first one is that the adjustment is consistent with the stated purpose and intent of the zoning ordinance. What is your opinion regarding this adjustment and whether it meets the stated purpose and intent of the zoning ordinance?
I don't believe it does based on what I previously mentioned.
Are there any specific parts of the zoning ordinance, purpose and intent that are applicable here, like light and air?
Light and air, character, inconvenience, and things like that. I think ultimately it's outside of the character of what this block is. There's no sort of inconvenience in terms of, like, there's no uniqueness to the actual property that makes this particular lot any more complicated or difficult to develop than anything else.
Would you say the character of the neighborhood is residential?
The character of the neighborhood is residential. The majority of the buildings are about 3.5 stories, 4 at best. Its architecture is pretty consistent. There's obviously, things from the late 1800s and the 1950s. There's stuff from the 90s, but overall, the expectation is this is a sort of, especially on the Wrightwood side, just a multi-unit residential building or character of the neighborhood.
And if it were a residential building, how tall could it be?
47 feet. There's a cap on that height for residential. There isn't one for a civic building.
And if there were to be a 65-foot tall residential building, would there be any impact on the setback?
Once you get into that height, there's precautions that are established on the building code side where that building would likely have a much larger side setback in order to provide proper light and air for that new construction building, which be anywhere in excess of 4 feet to potentially 7 feet.
I'd like to take you back to the narrative here on it's page 29 of the packet that I handed you that was submitted by Wrightwood 3 to the zoning administrator. And I want to take you, number 1 says the requested administrative adjustment is consistent with the stated purpose and intent of the zoning ordinance. And there's a paragraph under there. And taking you to the last sentence, it says the project has been designed to complement the existing museum uses to the east, preserving the large open space and existing mature trees on the east side of the subject property. Do you believe, what's your opinion of that statement?
Well, unfortunately, I think it's misleading. The property to the east is a vacant lot. The property to the east of that vacant lot is a single-family home. And then there's the current museum, which was built out of a multi-unit residential building. So it's present on the street, also looks like a residential building. And then in terms of trees, the majority currently in terms of the construction work that has already started on the site, a lot of them have been eliminated. And if the property were to be moved to meet the 5-foot setback that is standard, I believe based on the landscape plan, so this one that I reviewed, this one tree here would be eliminated, but none of the other ones would be compromised.
All right, looking at the next criteria, number 2 here, the requested administrative adjustment must eliminate an unnecessary inconvenience to the applicant, and it's not allowed to have an appreciable adverse impact on the surrounding property owners. Do you believe the administrative adjustment requested here meets this required criteria?
I don't believe it does. I don't see any inconvenience. If you look at the floor plans that were provided to the zoning administrator for review, if you can sort of see it here, I don't see anything on this building that couldn't be either designed or adjusted to make for a wider west side yard. The only thing that seems to be restricting the building from moving east is this little nub that's illustrated on the east side. It's about 1.5 stories tall. It's listed as an exit vestibule, but if you look at the plans, it doesn't show what it's exiting from. It's the back side of an elevator, which doesn't show any doors. It's also a couple of steps up, which I don't quite understand why you'd want to exit the back of an elevator that already is at grade and provides perfectly good access at grade for the building. So I would think if this is the only restriction to provide a proper side yard, I think that could easily be adjusted. There's plenty of room on the site. It's a 57.5 more wide site. The lot to the east is vacant, and these 2 properties used to be 50 feet. So that one example that you see there is that 2 flat. That was demolished, so was the 2 flat next to it. Those 2 combined were about 50 feet. So they clearly consolidated a little bit more of the 3rd lot in order to make it 57.69. They could have just added another 2.5 feet. So there's not a lot of inconvenience here that I can see.
Okay. This gets to the 3rd criteria as well, that the adverse impact will be mitigated to the maximum extent feasible. Is there any evidence in the you reviewed that shows that mitigation was considered?
Not that I could see. but I think there's ways to mitigate that. Obviously, the building could be moved. 30 inches or 25.5 inches was not a lot in a 45-foot wide building. Like I mentioned before, the consolidation of a little bit more of that third lot. These are extremely qualified architects. I'm sure design is a good solution. It's always a solution for a problem. Again, that nub is just a little bit unusual. It also has an odd condition as well that I also didn't quite understand. There's an opening, you can see it on the rendering. There's a front door to the museum that faces Wrightwood. There's also a very large door on the west elevation that faces west that looks more prominent than the Wrightwood entry, as it has it looks like about 16 feet, if not more, tall entry. It has glass on top of it. It's a more prominent elevation, a more prominent entry, yet it opens on a 2.5-foot side yard. I don't quite understand if a building code requires at least 3 feet, and for a building with this occupancy, it'd likely be more than 3'8". I don't understand why you'd have a significantly large door, double door, that leads to a tiny 2.5-foot side yard. So all of those things sort of just move the building a little bit, and I think all those problems go away.
I want to direct you back to the application narrative on page 29, looking at number 3, where it talks about the adverse impacts being mitigated. We've already discussed that you believe that there'll be adverse impacts from the administrative adjustment. The next sentence says the building on the abutting property is set back from the shared property line, providing sufficient building separation. How far is the abutting property from that shared property line?
The building to our building, you mean?
Yes.
We're about 1'9" roughly between, at least at the front, between Lisa's building and the property line. There's a very, very large setback between the single family home. Obviously, it's the side yard that it has is the vacant lot, and then another 5 feet that's proposed into their new construction. So there's a whole lot of room on the east side, but they're only giving us 2.5 feet on the west.
And then we already discussed that the statement that the proposed setback will increase the side setback that historically existed is misleading and
Yeah,
does not.
15/16 is not a significant increase worth mentioning.
In your opinion, does the requested administrative adjustment meet any of the required criteria?
I don't believe so.
Now, looking at the application, including the narrative and the site block, you identified several aspects that are misleading, inaccurate, or omit important context. In your opinion, are these misleading statements, omissions, and inaccuracies, are they material to the determination of whether the administrative adjustment meets the requirements?
Yeah, it's the information that the administrator had on hand, provided by licensed architects. So as a licensed architect, I want the city, anytime I submit something, to trust that what I'm submitting is accurate. Unfortunately, I don't feel that this is. There's a lot of errors in the information that they provided. I think they made a decision based on inaccuracies, and that's unfortunate.
In your opinion, why does this appeal matter?
It sets a precedent. We're expected to provide truthful information. We're also expected to, these are not sort of randomly handed out. So if this is approved, it's setting a precedent for other things to be approved based on inaccuracies. We're reliant on this process. We're reliant on the zoning ordinance. I've worked with it and enjoy the constraints of it for the last 28 years. So it's nice to be able to trust this stuff. But again, I also would expect that the administration trusts what I provide them.
Thank you. If the board doesn't have any questions for Mr. Dufresne, I'd like to call Ms. Barron as the next witness.
Sure.
And just to kind of do a roadmap for you, we're going to focus Ms. Barron's testimony first on her diligence in attempting to get the information that she needed to file a fulsome objection, and then the circumstances that prevented her from doing so.
Second.
Before I hear the objection, I would like this testimony to be limited to what's been presented to us as part of the application. We've all reviewed it, as we've done in our rules. We've all reviewed it. We know what they are. It's in the record. It can be reviewed. So I want to limit this to anything that is in addition to that, or that's not already been stated, if I may. And did you have
Point of clarification.
can you just state your name?
Thomas Raines, attorney for Objector Wrightwood Number 3 LLC. Just a point of clarification question. If they pass the witness, will we still be allowed to cross-examine Mr. Dufresne?
We're going to do this in three parts.
Okay.
We're going to have the presentation by the applicant. We're going to have a presentation, the response by the zoning administrator, and then we're going to go to the interested parties.
I just wanted to make sure we weren't
Yes.
waiving. Thank you.
Yes, you will be able to do that.
Okay, so the only, material, the only exhibit that we're seeking to have admitted, are the full communications between Ms. Barron and Mr. Martinez in the zoning office, that should have been part of the full file. We have a complete packet of them that we'd like to have admitted into the record.
That's okay.
And then, we would also like to just ask Ms. Barron a few, questions, related to that process, that were not, that were referenced but not fully fleshed out in the application. And then, the adverse impact. Her testimony will be short.
Okay. I'm not sure I understand with what you mean when you say not fully fleshed out. If it's actually part of what was originally occurred by the time that and expressed in the original application, it's really, all we want is to really limit it to that, because we have everything else and we need to move forward.
We just wanted to, yes, I'll just ask a few quick questions and,
Okay.
for Ms. Barron, who, as you know, is, lives at 675 West Wrightwood. How long have you lived there, Ms. Barron?
22 years.
Okay. And when was the first time that you saw the first, set of building plans for the current building, that's proposed?
For this building, on February 19th, when I visited the zoning administrator's office.
When did you receive notice, of the application?
Late in the evening on January 30th, I found a letter slipped under my back door.
What did you do when you got that letter?
I was leaving town the next morning on Saturday, and so I asked my mother if she could please go to the administrator's office because the letter said that there was only 10 days to review the documents and I was going to be out of town for that full period. She went that next business day, which happened to be Monday. She spoke to Sammy Martinez on the phone, in person, and they called me together on the phone to explain that I could not have anybody else find the documents for me and they couldn't be sent electronically, and that I would need to be there in person. Sammy agreed to allow me to come in person after I returned from my trip. I then sent an email documenting that, and we agreed to meet after the President's Day holiday, and the day he was available was February 19th.
Did you take any action in the interim, regarding the adjustment application?
Yes, out of an abundance of caution, I filed an initial objection without having seen the plans, just so that there would be something on the record in the event that something occurred where there was a decision that had to be made before the period I would be able to see the documents. I found out later that that 10-day period that was noted on the letter that was sent to me or slipped under my door is only the minimum amount of time that a zoning administrator has that they can make a decision post the 10-day period.
And I just want to direct the board to page 38 of the administrative packet. And then this is also Exhibit 1 in the exhibit book that you were handed. So this is in multiple forms, this email from Ms. Barron. And I just wanted to note that in the email, Ms. Barron said that it was a preliminary formal objection and that after a review of the plan, she would be revising and updating that based on the understanding of the proposal. Did you meet with Mr. Martinez on the 19th?
I did.
And what happened?
I was allowed to see a limited number of 8.5 by 11 documents regarding the property. We met in person. I was not allowed to take any photos or notes on any electronic devices. He had everything in a file folder and selectively pulled out different sheets to show me, one of which included a side elevation that at the time seemed like it was a very, very tall building. Not being an architect, it was listed as 165 feet tall. Obviously, I came to find out later that day via an email communication from Mr. Martinez that it's 65 feet tall. In fact, he thought that the limitation at the time that we were speaking was only 45 feet tall. And he clarified in the email that there's no height restriction on a private museum. I also saw a site plan that showed a west side exit that would have to use my property to be used. And I also understood from that site plan that it was a 57-foot lot. At the time, I thought it was only a 50-foot lot because the developer had told me that they had just combined two 25-foot lots. We discussed a block survey, which I learned what that was at that meeting. At that time, Sammy indicated that there were no side setbacks listed on it. Later that afternoon, he let me know that he did have a survey that had side setbacks. And I asked if I could come back to review that document the next day.
And were you able to review the document?
I was able to review it. It was very hard to read. As you guys might see in that book, reading these documents is really difficult when you don't have any way to magnify the information.
If you weren't allowed to copy the plans or make pictures of them, was there a recommendation on how to get the documents?
Yeah, Sammy actually taught me what the FOIA process was. So that was also illuminating. He explained to me that because I can't get any of the documents or take photos or get electronic copies, that I would have to submit a FOIA request. I did that on February 20th to ask for all the information within the package so that I would be able to review it, try to get some sort of insight or expert information and to understand, how to submit a full objection.
What happened between February 20th and February 25th?
I filed FOIAs and I waited, and Sammy and I communicated with regard to, he did try to clarify some information, like I mentioned, the height. I also noted some concerns that I had after sort of, the conversation that we had. I documented in email a couple of the concerns that I had regarding the lot to the east, that west side egress, the height, and the mechanical loft on the roof, which I was very concerned about. But we just communicated and I waited for the FOIA documents.
And in the interest of time, I will direct the board to Exhibit 20, which contains all of the email communications back and forth between Mr. Martinez and Ms. Barron during this time.
And are you saying that these weren't all, there was quite a few that we've seen? You're saying not all of them have been included in the application previously?
They were not all included in the application because we did not realize some of them were included in the administrator's packet, but not all of them. And so we wanted to provide a complete record of the communications. And that's what's in Exhibit 20. I'm sorry. Yeah.
Would have been included.
Right, these weren't double-sided.
Okay. So we are not going to accept that packet the ruling will be that because it's new information that was available at the time of the application and, or whether it was or not, well, it was because it was your communications. It's not, it's new to the record. We're not going to accept it because it's not fair to all the parties and because our rules are that we have to, the focus of the appeal and the focus of our deliberations has to be on what has been presented from the very beginning.
So Chairperson Schiller, I understand the ruling and I understand that it won't be admitted into evidence, but we ask if it can be submitted as part of the record as an offer of proof so that it is in the record for purposes of appeal with the understanding that it's not being admitted into evidence.
We do. I think that's something they just have to present it. I need a ruling. I need to know. We're not going to allow it to be part of the record as we're not allowing it to be included today in the testimony. I'm sorry, yes. Introduce yourself.
Yes, Madam Chair, Katie Jenke Dale from DLA Piper, on behalf of the interested party. As long as you're making evidentiary rulings right now, we actually object to Mr. Dufresne's testimony. He was not listed in the
Sorry,
packet as a
can you
witness
just say
list.
that again? I can't hear you.
We're objecting to Mr. Dufresne's testimony in its entirety because he was not listed on a witness list. He obviously existed when they filed the application as well. We were not provided his CV. He wasn't listed as a witness. We learned about his involvement today. So just while you're making evidentiary rulings, we wanted to flag
Well,
that as well.
I would like to be able to hear the rebuttal, both of the administrator and yourselves to that. So I really don't want to, maybe procedurally, I don't want to do that. I don't know if we can do that after the fact, but we will be making our decision based on the rules, the rules of evidence that we have with regards to, I mean, the rules that we have to follow with regards to the content of the application. But I think this, since it's there, it would be helpful for us to be able to hear all of the affected parties.
We're going to hold on ruling on your objection at the moment, but understand that it still stands and will be considered and ruled on.
Thank you.
After your testimony.
And before you rule, I'd ask for an opportunity to respond to the objection when you get to that.
Yeah. Yes, we'll have everybody respond. What else you got?
Thanks. So in the interest of time, we are not going to go through all of the emails. Some of them are included in the exhibits. But Ms. Barron, you were saying that you were emailing back and forth with Mr. Martinez and what
Well,
were you-
just to be clear, all of that is in the application. We have read it all.
Yeah.
We know what it is. We do not need to continue to hear about it. It's all part of our, it will be part of our deliberations.
And,
Just-
and I'd also like to point out, council, so the new process and procedures for this board, obviously all of the materials, the application are submitted, reviewed. They're all part of the record. And I certainly understand and appreciate the preparation that's gone into this, but this is not, obviously you have the opportunity to put on your witnesses and the interested parties will hear from. But those, again, those all of the materials have been previously reviewed. We're familiar with the processes, of course, and the standards by which we will be judging this case. Really, the opportunity here is to put on a very brief overview of the case, and then, of course, allow other parties to chime in. So with that, we'd like you to wrap up your initial case here, and then we can go ahead and move on to the zoning administrator.
I think I can probably have about 3 more questions if that's okay. For
Well,
Ms. Barron.
let's see what they are.
Okay. Ms. Barron, the application was approved on February 26th. Is that accurate?
I think it was the 27th, actually, yeah.
Were you surprised when that happened?
Yeah, I had just spoken to Sammy the day before. I had given him the information that I had not received any responses to my FOIA requests. And he suggested I speak to my alderman. I told him that I would reach out. I sent him an email later that day confirming our conversation and letting him know that I would be back in touch with him on Monday with an update on if I had received any FOIA information and, with information regarding the conversation with the alderman. I did speak to the alderman's representative, and they said they would get back to me the following Tuesday. So I was waiting for all of that information, obviously, to file a full objection.
And
Counselor, this is repeated information,
Yep, I did.
please. If, no more unless it's actually not already been included in either your narrative or in the emails. I'm not hearing anything new.
Okay. Last question.
If it's new,
Okay.
I'm going to cut you
Can
off.
I
if
confer
it's
1
not.
second to confirm that we have nothing else that is not included in the application packet? All right. No further questions at this time.
Okay, thank you. Administrator Patrick Murphy, please proceed.
Thank you. I'd like to start by reading a statement from our office, and then I'd like to go through a couple of responses to things that were raised in their testimony. For the record, my name is Patrick Murphy with the City of Chicago's Department of Planning and Development and the City Zoning Administrator. The appellant is currently appealing the decision of the zoning administrator to approve side setback relief pursuant to Section 17-13-1003 I-1. As a part of the administrative adjustment application, our office received an objection from the appellant stating concerns regarding potentially perceived adverse impacts on the surrounding residential property, which include impacts to light and air of the appellant's unit, as well as mitigation efforts. Regarding concerns related to light and air, it's important to note that the previous structure on the subject site maintained a 2.42 foot setback, meaning the relationship between the buildings is effectively consistent with the historic condition compared to what is proposed. The proposal does not seal off windows, eliminate access, or otherwise impede the functionality of the appellant's unit. In addition, the existing condition on the adjacent appellant's property at 675 West Wrightwood shows that such building is only 1.57 feet from the shared property line at its closest point. The appellant is objecting to relief for the administrative adjustment applicant when such condition already existed in a non-compliant fashion on the appellant's own property. Regarding mitigation efforts, the design intentionally locates gallery space with large windows facing east. Reversing or flipping the design to reorient the building would result in the gallery's windows directly facing and looking into the appellant's residential unit. The current configuration avoids the direct line of sight conflict. Also, as previously stated, the previous structure on the site was 2.42 feet away from the property line. The proposed yard depth of 2.5 feet is no closer than what existed prior. While those were the only issues raised to us during the review portion of the administrative adjustment process, the appellant has provided additional information not initially addressed in their original objection letter. The Zoning Board of Appeals rules of procedures adopted on June 20th, 2025, Section 3.9 specifically note that no new evidence other than what was submitted to the zoning administrator in rendering their decision will be accepted. That said, additional responses have been prepared should you choose to consider the new evidence that the appellant is now providing as a part of this submission. Regarding lot width concerns, zoning reviews rely on the submitted plat of survey and site plan. The legal description shown on the Department of Transportation house number certificate is not used for zoning determinations, as those certificates are generated solely by CDOT, not for permit review. While such initial proposal did involve a 50-foot lot, the applicant subsequently incorporated 7.5 feet from the lot to the east. A division of lot review was conducted during the permit review process, and the resulting zoning lot configuration was found compliant, and setback requirements were calculated based on this larger lot width. No issues were identified by city staff during the review regarding the lot size or width. From the information provided, the administrative adjustment applicant controls the adjacent eastern parcel and transferred the 7.5 feet of land to increase the east side setback. The city has confirmed the proposed zoning lot boundaries are acceptable. A survey reflecting the revised eastern property and an exhibit showing compliance with the applicable bulk regulations had been provided. Regarding concerns about structural impacts, including wind effects, snow drifting, or roof loading, those fall outside of the administrative adjustment review criteria. Structural matters are evaluated and enforced by the Department of Buildings as a part of the building permit process. Regarding access to the applicant's property, there's no indication in the submitted plans that any portion of 675 West Wrightwood is needed to satisfy egress requirements. There are no notes or indications that the appellant's property will be used for egress purposes. Egress and life safety provisions are exclusively under the control of the Department of Buildings. The statement that the design requires use of the neighboring property is not supported by their plans. With respect to the site block plan, staff conducted a full re-review of the provided information. Properties where accessory structures appeared to be identified by the administrative adjustment in the administrative adjustment application and used in their calculation instead of the principal building have been excluded from the overall calculation. In spite of that, the proposed project continues to meet the predominant yard depth for the block. Regarding ZBA staff uploading documents to the public-facing website that is unrelated to the approval of the administrative adjustment itself, and all documents submitted by the applicant, including the elevations, were reviewed by the zoning administrator as a part of the decision. The upload process used by the ZBA is separate from the zoning administrator's review and does not affect the validity of the approval. Regarding the newly raised issue of the front side of the front setback, this appeal concerns the zoning administrator's approval of a side setback reduction. This required front setback remains compliant with the ordinance. As the 80-acre map includes a 30-foot building setback line, our staff requested front yard information from other properties on the block subject to the same restriction. The data supplied by the applicant indicates that a majority of the other properties do not conform to the 30-foot building line. Based on that prevalent condition, we have determined that enforcing this restriction in this instance would be inconsistent and therefore unwarranted. Consequently, the property meets the front setback requirements of the Chicago zoning ordinance. In summary, information has been provided by the applicant that was unrelated to the administrative adjustment review and approval. The approval of the administrative adjustment is supported by the evidence, complies with the zoning ordinance, and does not produce adverse impacts that have not already existed due to long-standing site conditions. And then in regards to a number of issues that were raised during their testimony, I'll just read these in the order that I have them noted. In regards to the appeal and the reviews that were done related to the administrative adjustment and the side setbacks, the setback that was relevant for purposes of this administrative adjustment was the west side and the combined setback, not the east side setback for any of the properties on the block. In the RM5 zoning district, a museum is a permitted use. There was no zoning map amendment that would have been required, and height regulations, as was stated in some emails that our staff had with the appellant, the height regulations do not apply for principal non-residential uses. There was a question or concern raised regarding community meetings. As there was no zoning map amendment, there was no need for a community meeting, a requirement for a community meeting under the administrative adjustment process. In regards to the time taken to decide on this administrative adjustment, it was noted that that was abruptly decided by the department. The code requirement is, as was noted, a minimum of 10 days. There were 27 days that lapsed between the time of the notice being completed and the approval letter being issued. The predominance of the block, which was discussed earlier, was for the west side. And when I referenced in my previous statement about staff re-examining, that was done through the examination of surveys and building permits that existed, as well as 80-acre and parcel and lot line determinations that are available through the city's resources to reconfirm the information that was provided by the applicant, not a visualization or reliance on the presence or placement of a fence. And then finally, there is also affidavit and certified receipt of the notice that was properly issued to the applicant, and that is what we relied on in making our determination in regards to the timing and the awareness that the applicant had of the project.
Any questions? All right, interested parties. Let's see. You're up. So who is going to be speaking for them? Okay, so can you just identify yourself again for the record and explain? I'm sorry. Can you identify yourself again for the record and just clarify who you're representing and yes, start there.
We'll be brief, I promise. Good morning. Again, for the record, Katie Janky-Dale from DLA Piper. I represent the property owner that is impacted by this administrative adjustment, 673 Wrightwood LLC, or number 3 LLC. I brought with me today Katie Dans with the the property owner. I also brought with us Larry Kearns from Wheeler Kearns, who's the architect of record for the project, as well as Bill Bast, who is an engineer. I'm joined by my co-counsel, Tom Rains, as well. We are going to, I think the zoning administrator did a great job defending the merits of the administrative adjustment. We would agree with him, as well as I would just add, he covered the mitigation efforts very well. The only one that we would add is that the height of the building is primarily at the north end. The rest of the building was designed to kind of mirror the height of the appellant's property. In general, I think we just want to flag this application is really an abuse of the rules and process. For example, Council Wells was here last month. We were hoping to dispose of this matter. Back then, she used the fact that Council O'Keefe was out of town as the reason for a continuance, but Council Wells just did the hearing. Like I mentioned in our objection, Mr. Dufresne was not included as a witness in the packet. He showed up today. We don't know his qualifications. Is he a surveyor? We disagree with his characterization of the impact of the property to the east. He said only one tree would have to be demolished. We actually, our consultants have told us about a dozen century-old trees would have to be demolished if the building was moved. We don't know his method of measurement. So in general, I think that we wanted to be here today, first as a resource. If you have any questions for our consultants, I won't put them all on as witnesses, but we wanted to make sure that you had every resource available as you're considering this matter, and also to provide that larger context. But with that, I promise to be brief, but we're all here as resources if you have questions for our team. Thank you.
Council, can you briefly summarize for the record the extent to which there were communications with Alderman Knutsen's office regarding support for the project and/or the administrative adjustments?
Yeah, no, thank you. I'm glad you asked the question because, there has been extensive communication both with the Alderman's office, the city, as well as with the appellant dating back to April 2025, I believe, is when our client first engaged with Ms. Behrens. We also have continued communication with the Alderman's office and been in discussions with the Park West Neighborhood Association. I met 2 doors down last Monday with the leadership from the community organization. So I think, and to the point about the certified mail letter, the letter was slid under the door as a courtesy, but as you see, there was a certified mail receipt. And the reason why maybe it didn't arrive is because by the testimony today, she was out of town and couldn't have signed for it. But so I guess I'm glad that we did the courtesy of them slipping it under her door, but we have followed the process and procedures of the code to the T. Thank you. And you should have the letter from the Alderman's office as well as an email from last month.
It's in the record. Anything else?
I don't believe that we have that letter,
Yeah.
Madam Chair.
Oh, a letter from the Alderman? Is that what you're asking? I didn't see a letter from the Alderman.
I understand it was submitted to directly to the zoning board. Or zoning
What
board
we
staff.
have is the letter that was submitted to the, I'm sorry, what? Yeah, it would be after the fact. What we have is the letter of notification to the Alderman.
Oh, I'm sorry.
Yeah.
Yes, that also went.
If I may add, I know the alderman sent a letter of support
Yeah, it came.
this week.
So it wouldn't be in the record, but
Okay.
that's, yeah. But we know, yeah. Is there anything else? Did you have any other questions or clarifications you needed that you wanted to do from the applicant? And, right, but, and before we get to that, I really would like your client to be identified and to give us a name and address, and I just want the client, who's the actual person of interest, to be able to be on the record.
Hi, my name is Katie Dans. I am the manager of Wrightwood Number 3 LLC, and it is owned by an individual by the name of Fred Eichner.
Thank you.
Thank you.
And the ruling, I'm going to let you take it.
Madam Chair, may I make one response? I just want to clarify for the record that I was asked on Tuesday to do this presentation. This was not our intent for me to be here doing this, but for various reasons, I am the one. When the continuance was requested, Ms. O'Keefe was out of town, and it was the plan and intent until Tuesday for her to be doing this presentation.
Okay. Yeah. Oh,
Madam Chairman, I've had some health issues that prevented me from preparing for the hearing, which is why I could not participate as of Tuesday.
you want to identify yourself? for the
Sure. My
record?
name is Bridget O'Keefe. I'm with Marshall Brown. I've been involved with this case since April 7th.
Okay, thank you. Where'd she go?
If I can,
All right, so I think what we're going to do is, first, I want to ask if there are either from the zoning administrator or from the interested parties, any cross-examination you would like to do of the architect. And before we'll go first to the zoning administrator, I want to say that we're going to consider the motion, however, in deliberation. When we consider the whole thing, the motion as to whether that testimony will be included, but I want to make sure that all of the information is before us before we do that, and we will make that decision in closed session. And when we come back from closed session, when we do that, which will be later, we will also be coming back with with both the response to that and also our determination on the matter.
Madam Chairperson, may I just make one response to the objection?
Well, we're not doing yes, when we're done hearing the testimony from
Okay,
everybody.
thank you.
So.
I have no further questions regarding the testimony other than the responses I provided as to how we conducted a further examination of the setbacks in relation to the actual calculations as opposed to solely relying on a visual or walking analysis.
And just for clarity, you were doing it based on, not based on, there were two different issues about whether it was CDOT's information or the surveys. And can you
Okay,
just
so
clarify that?
The CDOT issue that was raised is a separate function that operates independent of permit reviews. Properties are assigned house numbers by the Department of Transportation to aid in both the Department of Transportation and the Fire Department and Emergency Services knowing where addressed properties are located. The information that was provided as a part of that original application was smaller than what was ultimately provided pursuant to their permit. But we, from a review standpoint of the permit, would have relied on the subsequent information, which included, like I said before, the valid plat of survey that depicted the proper enlargement of the zoning lot that was subject to the setbacks as they were calculated pursuant to the administrative adjustment.
And just for clarification, the plat of surveys are reflective of the legal descriptions of the properties.
Yes, correct. And then in further checking the other west side setbacks for properties along the block, the staff looked at permit information that we had, which would include surveys, which would include site plans. We also have access to 80-acre maps, which are used in platting the city's streets and public and private rights-of-way, as well as lot and parcel information to show the line, the actual measurement between properties and, or I'm sorry, between improvements and property lines.
Okay.
Madam Chair, I would just like to object to this testimony to the extent that none of that analysis or information was included in the packet provided by the administrator.
This appeal is of the administrator, therefore of his actions, and therefore includes his process, and he's been describing his process. So I'm going to deny that objection.
I would just like to get a clarification on the interested party's objection, just to, because the objection was as to relevance of the architect's testimony, because it wasn't made prior to the beginning of the testimony. The objection that currently stands that we've not yet ruled on is on the relevance and a request to strike his testimony from the record. Is that correct?
Correct, procedurally. He should have, if they intended to put him on today, he should have been included in their filing.
Understood. Okay, I just wanted to make sure that we had the
And-
proper objection on the record.
And what I ruled was that we were going to consider that along with the entire matter when we go into.
And then
closed
we'll
session.
rule on the objection.
Exactly.
Okay.
When we come back,
And-
we'll then say what our rulings are in both cases. Both on the objection and
And
on
on
the matter.
the substantive.
Yeah.
In one other thing in that regard, there was also a supplement to their filing that was allowed 2 weeks ago or a week ago. He wasn't included in that either.
Okay,
Understood.
understood. So did you have additional questions to the architect before we then hear the applicant's objection to the hearing and then we move on?
If you are to accept his testimony, there were a couple inaccuracies we just want to clarify. One is he noted that there was a door being shown in the image. That's not a door, it's a window. He also multiple times noted that he didn't understand the plans, and that's clear because that nook that he pointed out at the plan top is where the art will be brought in. So that's why that access is necessary. Like I already mentioned in my initial objection, he believes only one tree would have to come down if the building were moved. Again, I don't know if he's a landscape architect. I haven't seen his CV, but our experts have said, no, it would be about a dozen century-old trees. So I don't need to cross him. I'm not going to stand on procedure there, but if you were to accept his testimony, we just wanted to make sure that those clarifications were on the record.
Okay.
One other item I would note too is the images they're showing only are leaving out the east side of the proposed building, which is improved with 2 today Ondo design buildings. This would be perhaps his last in North America, where truly architect students from around the world come to observe his art. I met one of them in the gallery today who said he walks through the alley so he can touch the concrete. Stop doing that. But so, the importance of this, can't be understated.
Counselor?
If I can give I think Ms. O'Keefe has one response regarding whether Mr. Dufresne's testimony should be admitted. And then I would like to give Mr. Dufresne an opportunity just to respond to what was just said.
Okay.
Bridget O'Keefe for the record, with Marshall Brown. Prior to filing the appeal in April, I was retained April 7th, and right before the hearing was filed, or the appeal had to be filed because of the 45-day notice. I contacted the Zoning Board of Appeals staff. I spoke with them about the shortness of time, the fact that our FOIAs had not been responded to, the fact that we did not have the relevant documents. And I was assured at that time that we could introduce verbal testimony by an architect at the hearing. So I want to make it very clear that this was something, we never got the information, all of it, until late April. And even when the Zoning Board of, the record was filed with the ZBA, it didn't contain a full package. It didn't contain the elevations. I had to file the elevations to make sure we would have the opportunity to discuss them today. So I think it would be very detrimental based on the steps I took to confirm that this testimony, very vital testimony, very relevant to the record, would be allowed today. So I felt it was important for you to have that context, and I hope you'll keep that into consideration.
Okay, thank you.
Mr. Dufresne, do you have a response to those points that were just made by the interested parties attorney?
Just points of clarification. I stated that it was a large door. The window above it, it looks on the plans as a transom window, which is part of a door assembly. It just seems significantly large, and that space is a two-story space. In terms of your reference to the nub as a point of entry of the art into the building, I just want to point out that's a little confusing when it's listed as an exit vestibule on the plans, and the ground floor of the building is at grade, has a double door just to the north of that nub, and another double door on the front of the building, and another double door on the west side. It seems a little confusing to me as an architect that art would be brought up steps into the back of an elevator when it could remain at grade through a double door into the lobby and into the front of what's illustrated as the elevator. And in terms of trees, I am not a landscape architect. I am solely going off of the landscape plan, which was AA02, and there's only one tree on this plan that is close to the building. The other ones are much, much further. So just wanted to clarify that. I never claimed to be a landscape architect.
And if I could just follow up, Madam Chair, with Ms. Barron, who lives next door to the site and was there this morning, would like to add something to rebut the points about the trees.
The trees that are shown on this plan that is being projected, the 3 arrowed points, that entire land has been cleared. Those trees do not exist. In fact, we have a photo of what the current site looks like, and it is a complete dirt lot. So there are no trees where they have been indicated on that plan.
Okay, thank you.
Another issue that was raised during the testimony was regarding the information that was provided through the FOIA responses. Staff within the Bureau of Zoning, within our office, it does not fulfill FOIA responses. That is handled by another department or another bureau within our department. So the lack of information or the information that they believe they did not receive was not the result of actions by staff within the Zoning Bureau.
Right. Thank you. I think it's, yeah. And we're dealing with so just to be clear, the issues that we're dealing with here, the issue that we're dealing with here is explicitly the issue of the process of determining the administrative adjustment and whether or not that was proper, and actions therefore that relate specifically to that. And what you're saying is that the freedom of information is a process that's external to your department, to zoning, as it is to all departments. It is freedom of information is the access to the public for the public to departments, but it goes through them, not the individual departments.
Correct, and that's also why objectors to various administrative adjustments or other forms of relief that are administered by the city are able to come in and personally review items in lieu of whatever may have to be requested through FOIA.
Thank you.
Which was done in this case.
Okay. So, yeah.
The FOIA, because it's very important. I understand that DPD.
I'm going to object. I want to go to your to the summary at this point, the closing, because we've heard all of this. The FOIA request is whatever it's been mentioned. It was in the record. We don't need to continue to go over the same information, but we do need to move on. So we would like you to do your closing so that we can then proceed.
Thank you very much for your time today. As we said, this is the first time Ms. Barron is being heard on these objections. And that's because the evidence established that she was prevented from submitting a comprehensive objection to the application. She was in active discussions with the zoning department. She was waiting for those FOIA responses, which it's the only way to get the documents. Ms. Barron isn't an architect. She's not a surveyor. She's not an attorney. If she wanted to get the documents, she needed to get it through FOIA, and she didn't even get them until after this was approved. and she was acting diligently, as we discussed. There isn't any reason, there's no evidence, neither from the administrator or from the interested party as to why this administrative adjustment needed to be granted the day after Ms. Barron had said that she was planning on filing an objection, and it was approved without giving her any notice that she had no additional time to file a more fulsome objection. And it had only been pending for a few weeks. And the 19th was the first day that Ms. Barron had had the opportunity to review the materials. And then it was approved on the 27th. This is a due process violation if she's not allowed to have the other evidence that she has offered considered by the board because she was not allowed to present it. She was prevented from presenting it to the administrator. Second, the evidence established that the zoning administrator was provided and relied upon information that was inaccurate. It was incomplete in misleading ways. And the site block survey, just from looking at it, had obvious errors. That's why he erred in granting it. And then third, and most importantly, the heart of this objection is that the board should follow the governing law set forth in the zoning ordinance. This adjustment does not meet any of the criteria that the city council has said must be met in order for an administrative adjustment to be granted. An administrative adjustment, it's not a right. It is an exception. It's not a default. The applicant has to prove that it is entitled to this adjustment. And here, none of the criteria are met. Most importantly, I want to emphasize there hasn't been shown a need for this. As has been discussed, this property is the combination of two 25-foot properties. When that wasn't big enough, 7 feet from the neighboring property was conveyed. 9 feet could have been conveyed. In terms of what the zoning administrator said about flipping the building, there's never been a request to flip the building. The request is just move it over 25 inches. And there's no evidence in the record that that can't be done. The only evidence in the record is that some trees might be affected. But here we're talking about Ms. Barron living next to a concrete wall that's going to be 65 feet tall in part of it. And to her, those 25 inches are material for the light and air. And granting this administrative adjustment, what it's doing is favoring the property owner to the east, Mr. Eichener, who has a vacant property between this museum property and his home to preserve his light and his air and his view to the detriment of Ms. Barron. This administrative adjustment shouldn't have been granted. And also there was no discussions of mitigation. I didn't hear any discussion from the zoning administrator or the interested party about how they tried to mitigate this. If they reached out to Ms. Barron to discuss how anything could be done to mitigate the adverse impact that she's going to experience if this administrative adjustment is upheld. So we would accordingly request that the administrative adjustment be reversed and that the matter be remanded back to the zoning administrator.
Thank you. We will take both matters, on the substantive matter and the issue of the objection for inclusion of the testimony of the architect under advisement. Thank you. One recess, or do you want to take a session?
5 minutes.
Huh?
5 minutes.
Or do we want to go into? Do you want to recess? Do you want me to close it? Just recess. Let's just recess. We can deal with it later. Okay, so we're going to recess for 5 minutes. Make a motion to do so. Commissioner Soto seconds. Commissioner Gianni?
Yes.
Commissioner Hobbs?
Yes.
Commissioner Staley?
Yes.
Commissioner Soto?
Yes.
I vote yes. We're in a 5-minute recess.
Mike's on.
It got unplugged I think it got unplugged down there.
Her mic plugged. Sorry.
There you go.
That's what I did. Oh, we got it. We got it. We got it. Yeah. All right. I move that we reconvene. Commissioner Soto seconds, Commissioner Gianni.
Yes.
Commissioner Hobbs.
Yes.
Commissioner Staley.
Yes.
Commissioner Soto.
Yes.
I vote yes, we are back in session.
126E and 152. For 6125 North Cicero and 6160 North Cicero.
Okay, wait. I'm sorry, let me get to the right page. Okay.
Mhm.
All right, so what do we got here? Okay. All right, do we, and do we have, are there any other witnesses? Okay, well, no, there is, okay. I see. Okay, so, let me, I'm sorry.
It's
just
okay,
trying to
take
get
your
all that
time.
Stuff together here. Can I have all of the witnesses and the applicant, please raise your right hand? Do you swear that your testimony before us today, and are there any witnesses actually? No. Hmm? Yeah, there are, but no, yes and no. Could you swear that the testimony before, that you give us before us today will be true and correct?
Yes.
And the applicant, do you swear that the application is submitted continues to be true and correct?
Yes.
Okay, thank you. All right, so we have here, this is, I'm not looking at the right thing. Okay, here it is. So we have three of these items are special uses. And just before we proceed, I'm going to get to the recommendation of the Department of Planning. Let's do the overview first. I think it'll be
Okay.
easier. So Counselor, can you introduce your applicant and your witnesses and then give us an overview? And then when you're done, I will deal with the Department of Planning's
Brief
recommendation.
overview, council.
Thank you. So my name is Rolando Acosta. I am the attorney for the applicant. It's a pleasure to be here with you. To my immediate right, your left, is Teos Corte, Reverend Teos Corte. He is the president of the applicant. To his right, your left, is Louis Abuna. He is our traffic expert. And to his right, at the end of the row, is Peter Poulos. He is our MAI appraiser who did a land use impact analysis and discussed the standards for special use. I believe that Mr. Abuna and Mr. Poulos have appeared before you before, and I would ask that they be recognized as experts in their field.
Okay, yes, we recognize your expertise.
So the cases before you today, there's two special uses that relate to the building at 6125 North Cicero Avenue, and one special use that relates to the property at 6160 North Cicero Avenue. The property at 6160 is to serve as the off-site parking for the proposed uses at 6125. In addition, there's a fourth case, which is a variation to reduce the parking requirements for the proposed uses at 6125. At 6125 is currently improved with a two-story, 14,000 square foot, approximately 14,000 square foot building that is kind of an unusual building. It contains about 4,000 square feet of what I'll call office space on the first floor, about 2,000, on the second floor, about 2,000. It contains about a 6,000 square foot gym, which is laid out as a basketball court. It was constructed in 2010 as office and retail with an accessory private gym, but it was really never used that way. It was used starting in 2011 as a gym. And by 2016, it was clear that not only there was a gym there, but there was a basketball training operations for children in grades 3 through 8. The pictures that I've given you is a summary of our many photographs on many different topics that we submitted as part of the record. So they're all in the record already. I figured it was a little easier than clicking through a bunch of PowerPoints or flipping through a lot of pages for you. But the proposal is to operate a community center on the property. We believe it's properly laid out for that purpose. The community center would be operated by the not-for-profit. The applicant is a not-for-profit. They currently have about 50 families that they serve. They will host from Monday through Sunday a series of services. An example would be like, and I'll use their names, Mommy and Me, which is a gathering socializing for the families, music lessons in primarily classical instruments, Free to Be, which is a support group for families with special needs, children or adults, leadership training, basketball training, She Lives, which is a women's block club, supportive communal services, lessons on the Old Testament, Sunday in the afternoons, Sunday school. So that is the first special use. It's for the community center. The second special use is so that Sunday mornings between 9 and noon, they can hold religious services on the ground floor, 2,000 square foot of the building. The community center would operate 5 to 9 on weekdays, 10 to 6 on weekends. On Sundays, the services, as I said, would be 9 to noon. We anticipate a population for the community center, sort of maximum numbers, about 50 people. We anticipate for the religious services about 100 people. As I said, the building is already existing. It seems to be ready-made. There are no proposed additions, changes to the building. It actually was built, this retail office center with private accessory gym, has a basement with locker rooms, with lockers, changing rooms, etc. So it seems to be pretty ready-made for this. The requirement for this building, the building has 3 parking spaces. So that description of this building in the building permit application that gave them the permit to build allowed them to build this with only 3 spaces. Just about any other use we think of for this building requires more than 3 parking spaces. In our particular case, the Department of Planning and Development determined that we needed 15 parking spaces for the community center and 36 parking spaces for the religious assembly. Because the religious assembly is kind of duplicative of the population that would be in the community center, the total is 51. We've asked for the variation, the 4th case that we have, to reduce the parking by 8 to 43. The 3 on site, 40 off site. The off site location, 6160, is improved with 2 office buildings and contains 305 parking spaces. Of the 305 parking spaces, 72 are beyond, more than what is required by the zoning ordinance. So they have 72 excess parking spaces. We have leased on a perpetual basis, as long as this facility is operating, 40 of those spaces, the 40 most proximate, and you can see them now on the screen, to the community center building. So it's an easy identification of where the spaces are located. If for any reason we need more spaces, the landlord's happy to lease us more spaces. If you were to deny us a special use, we would just, I'm sorry, not the special use, the variation, we would just lease the additional 8 spaces to comply because they're there, they're available. I'm just trying not to have them spend excess money on something they don't believe to need. When we have 100 people at the facility, 40 spaces, given that these are families, are probably more than enough. They'll have sufficient staff at all times, and we'll get into this a little bit later, but one of the biggest issues that has been raised, I would say the most significant issue that's been raised, is the safety of crossing the street. So there are certain precautions that we are willing to take, that we intend on taking, to assure that that is safe. And
Okay, so I think, I want to go to the Department of Planning.
Sure.
And the recommendation, I'm going to let you deal with the recommendation of each of them and because they start the same, but then they are specific towards the end. So if you could streamline them, since we're dealing with these all as together, and just explain what the problem is with each of the special uses that you have and what your ruling is, your recommendation is, that would be really helpful. So introduce yourself for the record, and it's all yours.
Chief Zoning Plan Examiner with DPD. To sum it up, the issue is pedestrian safety and comfort. They're all related to all 3 of the special uses. If you look at the aerial, this will work. 6125 North Cicero, they're adding 2 additional new uses. The site is currently vacant. They're adding a religious assembly and a community center. They're adding pedestrian traffic from the building, and the crosswalks are located further north, so it will require individuals to walk from the site past northbound, cross over into the parking lot. Part of the issue is the data as shown in the application shows there's zero crash data because there's zero pedestrians. Our concern is getting these two uses and adding the amount of pedestrians to this current vacant site will provide an unsafe path for pedestrians who are leaving the establishment, whether it's during the operations for the community center or for the religious assembly. So that is our main concern. So it really leaves the issue of got to get people from the site safely and comfortable to the accessory parking associated with the application. Okay, that kind of sums up our position. Thank you.
All right, so, Counselor, can you want to rebuttal or
Sure.
now respond to that? Because.
Sure. And I'm happy to do this in summary fashion rather than going through all our witnesses. Obviously, everyone's available for questions. So there's two, I'm going to focus just on the DPD recommendation. So first of all, there are pedestrians that cross the street. There's photographs in your file and in the packet that I just gave you towards the end that show a series of pedestrians crossing the street at between 7:45 a.m. and 8 a.m. in the morning. Why? Because Sauganash Elementary School is immediately east of our site. And there's a neighborhood, a residential neighborhood, immediately northwest. So the north side of Hiawatha, from Hiawatha to basically almost Devon, is residential. There are children who live west of Cicero that have to get to Sauganash Elementary School. You can observe in the photographs, and I was asked by staff to blurt out their faces, so they're not identifiable, that the children are crossing at a crosswalk. There is a crosswalk, a designated marked crosswalk on the north side of Hiawatha, and also across Hiawatha to, you can see them on this photo, to the south side of Hiawatha. You can also notice on the photographs that there are pedestrian markings, the signs that we're all familiar with in the bright yellowish color that show that this is a pedestrian crossing. Mr. Abuna, as indicated in his traffic study, has also, he set cameras on the intersection and counted the cars and the pedestrians. And there are a number of pedestrians that cross not only in the morning, and the 7:45 to 8 a.m. is not only important because that's the time they have to get to school opening at 8 o'clock, but it's also the morning peak hour traffic. There are pedestrians crossing at Hiawatha based on the signage, based on the crosswalk. There's also pedestrian markings on the street, painted on the street. One is just north of Hiawatha on Cicero that says safety zone. One just north of Peterson on Cicero for northbound traffic that says safety zone. So it's very well indicated throughout this that this is a safety zone with a 30-mile-an-hour speed limit. We've got pedestrian crossing. Now you have crash data that Mr. Espinoza just referred to from IDOT for 5 years at the intersection of Hiawatha and Cicero, indicating zero pedestrian accidents and less than one vehicular accident per year. So we have pedestrians frequently crossing. There are no pedestrian accidents. We are obviously very concerned about the safety of the people who go to the community center or the religious services. These are families. The only reason for someone to be crossing is that they were parked. If they parked in the parking lot, obviously there's an adult present because only adults drive. The families will be all instructed to use the crosswalks, to exercise caution. This will be posted in the community center and the religious assembly space. They will be reminded verbally. We will also provide what is known as, what we have calling, crossing ambassadors. That's staff members who will be outside, both at the parking lot and at the community center, ensuring that people exercise proper crossing safety. In addition, the staff, DPD staff focuses on Hiawatha, but they forget Glen Lake. Glen Lake is the next intersection to the south. Glen Lake is a fully signalized intersection. It has pedestrian crossings. It has pedestrian counters. Among the photos that you see of pedestrian crossing to go to school in the morning, you will notice that there's a couple of families that actually live north of Hiawatha. So there's a photo of them walking down the western sidewalk of Foster south, past Hiawatha, to Glen Lake, to cross at Glen Lake. Similarly, our patrons at the community center will be encouraged to use the Glen Lake intersection. Again, that intersection was, Mr. Abuna reviewed that intersection. He noted the pedestrians that are on that intersection. That intersection was included in the crash data that was received by IDOT. Cicero is a IDOT street, so IDOT keeps this data. No pedestrian incidents. The third place that was looked at was the driveway that accesses the parking lot on Cicero Avenue. That was also reviewed by crash data. 0 pedestrian accidents in 5 years, 2020 to 2024. And the volume of cars is actually a lower volume of cars during the time that we are speaking. The peak hour for weekday traffic, as established by Mr. Abuna, ends at 4:45. We start at 5. The peak hour on weekdays is after noon, if I remember correctly, Louis, 11 o'clock on Sunday. So we looked at Sunday. So the volumes are not high here. You're talking about 5 minutes, basically a car every minute. I break it down by 15-minute increments. All this data is in your files. That maybe 8 cars a minute. That is not heavy traffic. So all of these precautions are being taken. There is clear evidence that there is safe crossing by pedestrians of these intersections at morning peak hour. The afternoon after school, 3 o'clock is not the street peak hour, so we didn't look at that as closely. And so there's clear evidence in the file. There's IDOT data to support it. There's Mr. Abuna's KLOA study to support this. In addition, and I'm just going to put this out there as a suggestion. So we think this is a perfectly safe crossing pattern. I want to say one thing before I say that. Any use that's made of this building will require parking. It will require more parking than can be placed on the property. And we reviewed this, so I picked up a couple of the logical uses, just so you understand it. These are all permitted uses in the B31 district. If I do a general restaurant, and a general restaurant can be like a sports bar, big bar. This is not the little service bar that we all like to see in the quaint Italian restaurants. I need 25 parking spaces. Where are you going to locate them? The property has 3. The biggest parking lot that's available, and you can see from that picture, the number of available spaces, is this parking lot. If I do an office use, 20 spaces. That's less than a combined Regional Assembly or community center, but it's more than if I just look at the community center. Medical office, a common use to our south, 25 spaces. And this is without sliding a floor over the basketball court and expanding the square footage. That would just increase it. Sports and rec. That's what I would have called this building when it was built. If it were sports and rec, just counting the square footage of the basketball court, I need 71 parking spaces. They built 3. So if this use doesn't go in and another use appears, they're probably going to be right here asking for exactly the same thing because there's no place else to park. To the east is all residential, single-family homes. So the funeral home obviously has different hours. The only parking lot available sort of after business hours and on weekends is 6160.
Counselor, can you just tell us on the site map, on the overview map here, it looks like there's multiple other parking spaces for different uses that are across the street.
Mhm.
You know what they are, who uses them?
Sure. So the ones that you see surrounding the funeral home, kind of south of the blue line.
Yeah. I
South,
see.
yeah. Those are the funeral home parking spaces. I believe that the ones that are sort of towards the back, close to the Edens Expressway, are used by the Polish National Alliance that you can see at the very bottom of your screen. The 305 parking spaces are the ones that are servicing the 6200 North Hiawatha building and the 6160 North Cicero building. There's also, part of them there's 60 underground, so you don't see those 60, but the remainder, 255 spaces are above ground. And you can see from this photograph, we're going to use the ones, propose to use the ones closest to Cicero Avenue. They're visible from the front door of the building. The front door of the building is visible. You can see the crosswalks marked on the ground photography that I've provided. You can see the signs. There's also photography showing the safety zone markings on the pedestrian streets and the crash data. In that little packet that Mr. Reza gave you, I have the crash data in there for your review.
Thank you.
The one I wanted to tell you, one thing that we're willing to try to do, but we cannot be held to it because it's beyond our control. We've started to explore as a way to enhance further pedestrian safety. Again, we think it's safe, but if someone wanted to put the cherry on the ice cream sundae, this would be it. There are activated flashers that nowadays are solar powered and can be, there's a button you can press to activate them so they're not on all the time. Unfortunately, Cicero is a IDOT right-of-way, and I have to get permission from IDOT. I've started to explore that with IDOT. I cannot assure you of what would happen when I'm through that IDOT process. But if IDOT were to approve it and CDOT were to allow it, the applicant would commit to funding the installation of these flashing lights, which would benefit not only its population, but all the population. There's pictures of a child crossing Cicero at 7:45 in the morning on his bicycle, no adult. The other thing I want to remind you is, remember when I talked about the basketball facility that was in this property? It was for, and there's a photograph of this, their sign, grades 3 through 8. That's the same age group that I think everyone's worried about, which is the little kids. So that is my rebuttal.
Thank you. So we have here the Chief of Staff for Alderman Nugent. Can you introduce yourself and then give us your statement?
Of course. Good morning. My name is Adam Roberts. I serve as Chief of Staff for Alderman Samantha Nugent, Alderman of the 39th Ward. Good morning, Chair Scheller and members of the board. After reviewing the proposal, speaking with residents, local businesses, and community leaders, Alderman Nugent opposes this project. The proposed off-site parking agreement for this project would require attendees to cross 4 lanes of Cicero Avenue to access the building at 6125. This creates significant safety concerns for pedestrians, especially during large events. Despite traffic calming measures in this corridor, many of which have been mentioned this morning, speed cameras, signage, and traffic lights, Cicero is unfortunately still incredibly dangerous and functions as a highway. This is, in fact, Illinois Route 50. Unfortunately, just a few years ago, a young boy was hit and killed by 2 cars on Cicero Avenue just up a block from this. The accessory parking lot across Cicero increases risks of unsafe crossing and the potential for other severe incidents. Additionally, the proposed off-site parking, as illustrated in the photos above, is poorly marked, and there are no physical barriers between the office parking lot and the funeral home parking lot. While signs, of course, could be placed to note designated parking, it should not be the funeral home's responsibility to enforce parking when attendees park in the funeral lot instead of the office lot because it's closer to 6125 and to cross at Glen Lake. While this accessory off-site parking may seem like a solution on paper, it will create a ton of real examples of practice and extreme problems. After discussions with the neighbors, business owners, and the Saguenash Community Association, Alderman Nugent objects to this application and supports the denial of the department. Thank you.
Thank you. I'm going to have us, I'm going to have us consider it. Take it under advisement. Okay, do you have anything else?
I would like to address that,
Okay, please.
if I
do.
may. Okay?
And address that and then maybe do your closing.
Absolutely.
Okay.
I'm all for efficiency, okay? So first of all, I'd like to address the incident, the unfortunate incident, tragic incident of the boy. That is one incident. It's 2 blocks north. It was the 6300 block. I've got the Tribune article if you'd like to read it, of this. At approximately 9 o'clock at night, a young boy, 5 years old, slipped out the front door of his house while his father was in the backyard. Tragic, unfortunate, an accident. He wandered into the center of Cicero Avenue, and he was hit by a car, actually 2 cars. Okay? It's horrible. But that is an accident that can happen anywhere. And that is no reason to deny this when it's clear that many children are crossing Cicero Avenue. If there's such concern for children crossing Cicero Avenue, where's the concern for those children in the morning when they're going to school? I mean, they're doing it now. And the only people who've come up with this idea of flashing lights is us. It's clearly safe, it's clearly being used, and one incident is being used to justify this. As far as the marking of the parking lot, there's actually a curb between the funeral home parking lot and the office parking lot. The blue line is obscuring the curb if you look on your plan. Our patrons will be instructed where to park. They will know. Maybe they get it wrong one time, but they won't get it wrong 2 times. We have heard no objection from the funeral home. Mr. Scorte talked to the nearest business to the south at Glen Lake, which is a hamburger. I call them hamburger joints. I apologize for the layman's term. They're supportive. Why? There are many vacancies occurring at Peterson and Cicero. They need more people. We'll bring some people that can eat there. They can eat at the other restaurants. And so they showed no objection. I've tried to reach out to the community groups. They're, quite frankly, over months, non-responsive. So I can't communicate with people who don't want to call me back. We're happy to meet with people. For those who know me for a while, know that I'm happy to meet with anyone, talk about anything at all times. But I can't meet with people who don't want to meet with me and address these issues. We believe we have data, we have facts, we have evidence that shows that this is safe. The objections are speculation. This board makes decisions based on evidence. We have evidence based on Mr. Poulos's report and the photographs of this neighborhood that these proposals are compatible with this neighborhood. We have evidence based on Mr. Poulos's report that there is a need for this. This is a Romanian-based Christian church and community center that's trying to serve 2nd and 3rd generation Romanians who don't necessarily speak Romanian. And the only services in this area are performed in Romanian. I would face the same issue if I sent my family to a Spanish Catholic church that only spoke Spanish. My grandchildren do not speak Spanish, unfortunately. I've tried, but I'm not in charge of anything. So this is a needed use in the community. You have a building that almost is tailor-made for this use. And again, there's stated concerns about safety. We don't agree, but they're going to face the same issue no matter what you put in this building because it's got 3 parking spaces. We are going to have a controlled situation. We're going to have a well-managed population. We're going to have staff on the street to make sure that this happens. We're going to instruct all patrons to exercise safety, and we have the crash data.
A couple questions. What are the hours of operation for the different activities?
So the community center is 5 to 9 on weekdays, 10 a.m. to 6 p.m. on weekends, and there's scheduled activities. This is not a free-for-all. So I actually have a schedule. So 5 to 6:30 is mommy and me on Mondays. 6:30 to 7 is music lessons. You're not going to have 100 people.
Yeah, I just wanted, I guess I just want to know whether or not, I'm trying to understand if there's specific times and that there will be people coming and going and using the parking lot.
Okay, so it would be, for the community center, 5 p.m. to 9 p.m.
Okay.
give or take, right? Because a little before, a little after. For the religious facility, the religious services, it's Sundays. That's a low, Mr. Rabuna could testify, but it's a low traffic day. And Sundays, it's services start at 10. We have stated 9. Some people will start early, arrive earlier, and they will end at noon.
At noon.
And the community center pretty much will not be operating then because we hope everyone will be at services.
And the community center operates Monday through Friday or Monday through Saturday?
It operates Monday through Friday, 5 to 9,
Mhm.
Saturday and Sunday, 10 to 6. And by the way, it's open, it's free,
Except- okay.
free of charge, open to everyone, even if you're not Romanian or Christian.
The Sundays, it's 10 to noon for the service, but it's actually open till 6 for the other
It is,
activities?
yes,
Okay.
because we'll have Sunday school after, for example, after the religious services.
Okay. Anything else?
Any questions? Happy to have the
Okay.
witnesses say more.
So, no, I think we've got it. We'll take this matter under advisement. Thank you.
Thank you.
Oh, thanks. Okay. Well, wait, I might need that from when we go in the back. Oh, you can keep that up there. Now maybe we'll move along. Okay. Phew. Morning.
Hi.
Morning.
Okay.
Hello.
Make sure what we're doing here. This is the second item. We are at Division Street, right?
Yes.
Okay, perfect. All right, so who do we have here?
So good morning. My name is Sonorio Torres. I'm a director of business initiatives for the Puerto Rican Cultural Center. I've provided technical assistance for the applicant, Reynaldo Oquendo.
Okay. So and you're the applicant,
Yes.
and your name is?
Reynaldo Oquendo,
Okay, and your address?
2719 West Division.
Okay, and so you're here as an advocate for as a community community organization
Yes.
who's
Supporting and
supporting-
provided
support-
technical assistance with
Okay.
the process.
So we need the testimony from the applicant, and this is for hair salon and barber shop.
Right.
Okay, perfect. I am going to pass this on for, thank you. Raise your right hand. Do you swear that your testimony today before us will be true and accurate?
Yes, I do.
And do you swear that your application as submitted will continue to be true and accurate?
I do.
Okay, perfect. Carry on, Commissioner.
So you're trying to establish a barber shop and a hair salon at this location?
Yes.
Okay. Do you have the necessary licenses to perform services? Will you be cutting hair yourself or will
Yes.
you be, okay. Will you also hire others to support the salon as well?
Yes.
Will you ensure that they will also have the necessary licenses to perform those services?
Yes.
What are the hours that you would like to have
9 a.m. to 6 p.m.
7 days a week?
6 days.
6
Close Sundays.
Closed on Sundays? Okay. How many staff do you anticipate hiring when you're at full capacity?
4.
4? Okay. Those are all the questions that I have.
Okay, and I have a recommendation here from the Department of Planning that recommends approval.
Oh, thank you.
All right. I move that the matter before us be approved. Commissioner Soto seconds, Commissioner Gianni?
Yes.
Commissioner Hobbs?
Yes.
Commissioner Staley?
Yes.
Commissioner Soto?
Yes.
I vote yes, the matter is approved.
Thank you, commissioners.
Thank you.
So much.
Oh, the whole last page. Okay. Hmm. Oh, okay. Yeah, but he didn't register as Mr. Party. Yeah. 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 Well, they brought everybody. All right, we all situated? Okay. um, Ready?
Ready to go.
All right, so can I get the applicant and witnesses to raise your right hand? Do you swear that your testimony today before us will be true and correct?
Yes.
And for the applicant, do you swear that the application is submitted continues to be true and correct?
Yes.
Okay, thank you. Counselor, can you introduce your folks here and then give us a brief overview?
Absolutely. So thank you again for the record. Nick Fatikas from the Law Offices of Sam Banks. With me today, on behalf of the applicant is Prakash Kruvilla. I apologize for that. Our project architect, Warren Johnson, and our MAI appraiser, Terry O'Brien. The case involves the subject property at 2346 Northwestern Avenue. My client has a contract to purchase, at least with an option to purchase the subject property. And it's an 11,346 square foot lot that currently has a dormant gas station, a 3-pump gas station. The gas station actually operated for nearly 40 years. Unfortunately, during COVID-19, it closed, and the 18-month period where it could be reestablished had already lapsed. So we're looking to reactivate the gas station and convenience store. And in order to do that, we're seeking a special use because the subject property is located in a B3-2 zoning district. We're also seeking companion variations to permit the reestablishment of the gas station based on the lot area total, and then in order to comply with the EOT standards. And as a quick housekeeping matter, Madam Chairman, in working on our plan review, we were actually able to confirm that the transparency calculations met code. So I believe we can voluntarily withdraw the variation request 16526Z as being moot because the plan as presented was complied with the transparency requirement. And second, I just want to make sure the board was aware when we were originally scheduled for hearing back in April, it was continued by the alderman for further community review. Since then, we did meet with the GGNA community organization actually on May 11th, and we're not aware of any pending objections or concerns. In fact, I believe we have their support for today's proceeding. Our full team is here to discuss the project, and we're happy to answer any questions you or the commissioners have.
I have one question. I need, so this is a, well, actually, first, there is a recommendation from the Department of Planning. Have you had a chance to review this? Has the applicant had a chance to review this?
Yes. Oh, yes.
Yes, yes, sorry, I'm sorry.
And do you, it is a recommendation of approval, providing that the special use is being issued solely to the applicant yourself, and that the development is consistent with the design and layout as presented in the application. So yes, that's a yes, you agreed it. Okay, so, but my question is, explain to me the reduction in the lot size and how that affects the area. It seems kind of.
Yeah, so in order to establish a new gas station per code, the subject property is supposed to have at least 20,000 square feet of lot area total. For lots less than 20,000 square feet, and it's a pretty common ask in front of the zoning board, it's a variation issue.
No, I understand that. This just seems to be a lot. So can you explain how this works?
Yeah, so we're looking to reestablish the station. We have, based on 40 years of operational history, we know that it can function with a three pump gas station and a convenience store. In fact, if you go back to the visual or the photo of the subject property, the prior operator on, we'll call it the left, which would be the south side, actually also had a small service area, so they would do small repairs. We're not proposing repairs, or actually we think we're reducing the intensity on site. We are going to expand within that footprint, the convenience store, just to make it a little bit more spacious and have a little bit of a better customer experience. But the three gas station pumps are going to remain the way they are. We're not looking to increase the capacity. It is a smaller site, but the only way for us in terms of reestablishing the use is the variation, because we can't change the lot area total. It's a fixed number. Again, the benefit, I'm being a little bit redundant, is that it had proven to support the use for nearly 40 years prior to COVID.
And has CDOT reviewed the direction of the entrance and exits?
Yes, and what we did, the way the property is currently configured, there are 4 total driveways. We're going to close the closest one. It's shown on the top at Fullerton, nearest the intersection. We're ultimately reducing one of the driveways to improve pedestrian safety and comfort. It's a little bit unnecessary, that particular one, but as we showed in our exhibits and plan review, the vehicle circulation, more so the truck circulation, requires the second curb cut on Western Avenue. But again, a net reduction in the total number of driveways serving the property.
So the lighter gray and the darker gray?
Are just vehicle movements showing what the options for a delivery truck, a gas truck, they would
Either
enter,
way, okay.
exactly. So there's an option to go
Else.
left or right out of the property. That's it.
Okay, thank you. Anything else? We're going to go to objectors. So are all 3 of you here to object?
All 3 of you testifying?
Are all 3 of you want to make a statement?
Are,
Will each of you make a statement? Is my question.
are each of you testifying, or is only one of you testifying on behalf of all?
Yeah. I will be speaking.
Okay, so you are, this is a public statement, so you have 2 minutes. And the mic is all yours. If you could start by introducing yourself and giving us your address.
My name is Al Giannini. I'm a real estate broker by profession, and I'm here to support my friends who are family members of the principals of the BP gas station on the southeast corner of Western and Fullerton.
Chair, I would object. Again, BP is a competing gas station. And it's
That's
clear
okay.
in
This
the
is a
rules.
public statement.
That's fine.
Yeah.
Thank you.
Yeah, we understood that.
Okay, we have no ill will towards the project owner and wish them success, but not in this project as a gas station. The property is just over, as the attorney mentioned, it's just over 11,000 square feet, which is well below the 20,000 suggested minimum that's typically required for an expanded or a new gas station. More importantly, a recently adopted zoning ordinance restricts new or expanded gas stations within 1,000 feet of another station and on blocks with residential buildings. This site is only 50 feet from an existing gas station and next to a residential condominium building. This appears to clearly conflict with the ordinance, which was intended to protect and improve the community. Approving a gas station here would not only undermine that ordinance, but also create unfair competition for the nearby gas station and negatively impact nearby residential property values. In our opinion, the highest and best use for this property is retail, potentially with residential units above, but not as a gas station. We respectfully request that this board deny the proposed project as a gas station. Thank you.
Okay, thank you. Yeah.
I just, 2 quick points on rebuttal. The first is, we know the competition is not a basis for
Right.
objection, but more importantly, the objector referenced the new gas station ordinance, which does have situs limitations or restrictions between gas stations. As recently as last month, Alderman Irvin passed a subsequent amendment to that ordinance, allowing a type 1 zoning change to overcome the separation requirements, both with respect to other gas stations as well as to residential blocks with residential zoning on the same block face. So I respectfully disagree that this would be inconsistent with the ordinance. We also filed this application prior to the institution or the passage of the original change in the ordinance. So we are wholly provided special use and variations are approved, we would be wholly compliant with the zoning.
Okay, so
ordinance.
for just point of clarification, what you're saying is that in any case, you had filed before the change in the ordinance,
Absolutely.
and consequently, there had been another change to the ordinance which would allow you to do this even if you hadn't done that.
Correct.
Okay, thank you. Anything else from anyone here? Can we vote? Okay. Right. Right. And just for clarity, for the objectors, competition is not, is explicitly excluded from consideration by us on these matters. So first, I move that we withdraw, that the application number 16526-Z be withdrawn. Commissioner Soto seconds. Commissioner Gianni?
Yes.
Commissioner Hobbs?
Yes.
Commissioner Staley?
Yes.
Commissioner Soto?
Yes.
I vote yes, that matter is withdrawn. I move that item, let's get the numbers right, 164-26-S, 166-26-Z, 167-26-Z, 168-26-Z be approved. Commissioner Soto seconds, Commissioner Gianni?
Yes.
Commissioner Hobbs?
Yes.
Commissioner Staley?
Yes.
Commissioner Soto?
Yes.
I vote yes, these matters are approved.
Thank you.
Okay, 1226, that's on page 2, 5801 South Front.
Thank you.
The next next one, yeah.
Good morning.
Presuming the applicant and experts, please raise your right hand. Do you swear that your testimony before us today will be true and correct? And for the applicant, do you swear that that the application is submitted continues to be true and correct?
Yes, ma'am.
Great. All right, Counselor, introduce your folks and give us a brief overview.
Perfect. So again, for the record, Nick Fatikas from the Law Offices of Sam Banks. I'm here on behalf of Holistic Alliance. On behalf of that entity is Dr. Sheila Martin. We also have our project architect, Bill Kokalius, and our MAI appraiser, Mr. Joe Ryan. Chairman, in this case, again, Holistic Alliance is a not-for-profit organization that's working to provide housing for individuals dealing with housing insecurity on the south side of Chicago and in suburban Cook County. The organization owns the subject property at 5801 South Marshfield, which is in the 16th Ward. The subject property measures approximately 47.3 feet wide by 121 feet deep, and it's improved with an existing multi-unit residential building. The applicant is proposing to adapt and reuse the existing building and establish it as a transitional shelter. The shelter will operate with 17 bedrooms and a total of 38 individuals, so a capacity of 38 individuals. In order to permit the use, the applicant is seeking a special use because the property is located in an RS3 zoning district. And Chair, the hearing packet submitted with our application addressed a lot of the operational points, but I do want to just highlight a few of them quickly. First, the facility will be staffed 24 hours a day, 7 days a week. Clients range anywhere between 24 hours and 30 days, but they're not allowed to establish permanent residency. And in addition to providing temporary shelter, which is obviously critically important, the team will also offer on-site services such as case management, access to healthcare, scheduled meals, and even job training and placement. Holistic Alliance has and will continue to partner with the Illinois Department of Human Services and other local social service agencies in efforts to combat homelessness and housing insecurity in the community. We've worked very closely with Alderman Coleman on this project. I believe we have her full support today, and our team is available to answer any questions you or the commissioners have.
Okay, and let me add that there has been a recommendation of approval by the Department of Planning with as long as this is provided that it's issued solely to the applicant, as you know. Well, have you read this? I mean, I think you've already stated all of that it's to the applicant solely, that it's for the 38 limit of for no more than 38 residents
Yes.
residing there.
Yes.
And that the layout, that what you do will be consistent with the layout as presented in the application, and that it'll be exclusively utilized as a transitional shelter for individuals experiencing home, housing insecurity.
Absolutely, Commissioner.
Okay, perfect. So you agree with that? And anything from anyone on the?
No, just thank you for providing these important services. Really
Yeah.
appreciate it.
Thank you.
Important
Second.
work.
All right, I move that we approve this matter be approved. Commissioner Soto seconds, Commissioner Gianni.
Yes.
Commissioner Hobbs.
Yes.
Commissioner Staley.
Yes.
Commissioner Soto.
Yes.
I vote yes, the matter is approved. Thank you very much.
Thank you.
That's same applicant, 7 South Precinct.
Okay. How far is it? Oh. All right, same team, same discussion.
Yes.
Can I well, you've already been sworn in.
Yes.
But okay, so we'll swear you in one more time.
Yes.
So do you swear that your do you swear that your testimony before us today will be true and accurate?
Yes, ma'am.
And
Yes.
do you swear that the application is submitted continues to be true and accurate?
Absolutely, yes.
And for the record, again, there's approval by the recommendation of approval by the, you can put your hand down.
Oh,
There's a recommendation by approval by the Department of Planning to establish a transitional shelter for up to 48 individuals,
Yes, ma'am.
provided that, again, all of the same things we said before, which is that it'll be solely issued to the applicant, to your organization, that it is consistent with the design and layout as submitted in your application, that it'll be exclusively utilized as transitional shelter for individuals experiencing housing insecurity, and that, again, there'll be no more than 48 residents.
Yes, Commissioner.
Okay, so you agree with that? That's here. Any additions to your end?
I could really reincorporate the summary. The only difference is, again, the layout's a little bit different. In this case, we have 9 sleeping rooms, again, a total capacity of 48 individuals. And this property also includes a piece at 7004 South Racine, which is currently just kind of a vacant lot. We're going to be able to put 4 parking spaces there. Again, most of the folks that are coming to the facility don't
Don't have
have cars, so parking isn't necessarily a significant concern. However, when people are visiting, when program staff people come, it's nice to have that offer. So it's a little bit of a bigger property. Again, 48-person capacity, 4 parking spaces, same applicant, same program.
Okay, great. Different ward, though.
Different ward, and we have worked with the alderman, and I believe, again, I don't know if he provided a letter of support, but we do have his support for today's
Okay, great.
application.
Anything else? Anybody?
I reiterate my thanks. for the Important services.
I just
that-
want to say that we will do our communities. I live in the community. We do our communities well. Yes,
I'm sure you will.
yes.
And
we will.
the value of you doing it, especially in different locations where the
Yes.
need continues to be, is greatly
Yeah.
appreciated.
Thank you. Thank you.
All right, I move that this matter be approved. Commissioner Soto seconds, Commissioner Gianni.
Yes.
Commissioner Hobbs.
Yes.
Commissioner Staley.
Yes.
Commissioner Soto.
Yes.
I vote yes, the matter is approved.
Oh, finally.
Sigh-
Thank you.
A big
Thank
sigh,
you.
right?
Thank
It's 20726S, 20826E, 20926E, 21026E, 1548 West 14th Place.
Who's the attorney? Nick. Okay. Okay, boy. Ready? All right, can I get the applicant and architect to raise your right hand? Do you swear that your testimony today before us will be true and correct?
Yes.
And for the applicant, do you swear that your application is submitted continues to be true and correct?
Yes.
And so we have, so council, go ahead. We'll do there are many items here and then there's a special use. So, and do the overview and then we'll deal with the specials.
Perfect. So again, Nick Fatikas from the Law Offices of Sam Banks. I'm here on behalf of the applicant and property owner, Hellas IMD LLC. With me today is one of the managing members, Tom Vitogiannis, and our project architect, Bill Kokalius. The applicant, again, owns the subject property at 1548 West 14th Place. It's a slightly irregular lot, measures 48.3 feet wide by 125 feet deep. It's also a corner lot with frontage on both South Ashland Avenue and West 14th Place. The let's call it about 6,037.5 square foot lot is currently vacant land. The applicant's proposing to develop the property with a new 4-story, 8-unit residential building. Although the subject property is located in a B33 zoning district, it's south of the commercial intersection at Roosevelt, and it actually neighbors several other multi-unit residential buildings. So in order to permit our project, the applicant is seeking a special use to permit residential uses below the building's second floor. And we're also seeking a series of variations to increase the building location standard and actually provide a little bit more of a setback from the sidewalk from 5 feet to 6.75 feet. We're also asking for permission to have a side building entrance on a TSL, which is again part of the TSL design guideline. The third request is a reduction in the perimeter landscape setback along West 14th Place, and that's reducing it from 7 feet to 3 feet 3 inches. And then lastly, we're asking to increase the parking ratio from 50% or 4 parking spaces to 62.5% or 5 parking spaces. All 4 of the variations are directly related to the subject lot's designation as a transit-served location, which again imposes the pedestrian street design guidelines, even though neither segment of South Ashland or 14th Place is actually a P Street. And again, on top of that, we're a corner lot with a slightly irregular dimension. Our team's here to answer any questions if you or the commissioners have them.
This is across the street from the Costco?
Yep. Yep. Yeah, between the Costco and the fire
That-
pitch right behind it. Yep.
Right, got it. I know where, I was trying to place it. Any questions? Okay, so there is a, for the special use, which, there is a letter of recommendation from the, Department of Planning and Development, and, it provided that you've utilized the, architectural drawings as submitted with the application. If there's nothing else, then I, move that we approve these matters, and Commissioner Soto seconds, Commissioner Gianni?
Yes.
Commissioner Hobbs?
Yes.
Commissioner Staley?
Yes.
Commissioner Soto?
Yes.
I vote yes, the matter is approved. Oh,
you.
just one question. Is this rental or condos?
Rentals.
Okay.
Thank you, commissioners.
Thank you.
Good afternoon now. Okay. First time in a long time then, in the morning session, we've said good afternoon.
Let me go out with a bang again.
We're almost there. Good morning, I mean, good afternoon.
Good afternoon.
So can I have the applicant and witness, please raise your right hands. Do you swear that the testimony before us today will be true and accurate?
Yes.
And for the applicant, do you swear that that your application is submitted continues to be true and accurate?
Yes.
Okay, perfect. The counselor, if you could give us a brief, introduce your folks here and give us a brief overview, and then we'll deal with the special use.
Good afternoon, Madam Chairman and members of the board. For the record, my name is Nicola Patinsky from the law offices of Samuel VP Banks, located at 221 North LaSalle Street. I'm here on behalf of the applicant, Kalias Mayor Israel. The applicant is an Illinois not-for-profit corporation that owns a subject property located at 7154 North Francisco Avenue in Chicago's West Ridge neighborhood. The subject lot is substandard with respect to its width and depth dimensions of approximately 123.3 feet and 92 feet respectively. It's also irregular with respect to its shape because it has a varying depth dimension of 91.81 feet and 92.4 feet. The subject site is improved with a one-story masonry building with an attached one-story frame structure and off-street surface parking at the rear. The applicant has operated in a religious assembly facility at the subject property for the last 5 years. The synagogue has been successful and its congregation has grown over the last few years, so much that it has outgrown the existing space. In order to meet their needs, the applicant is proposing to construct additions on the south side of the lot. The southwestern and southeastern additions would add approximately 1,741 square feet and 903 square feet of total lot area, and would measure 15 feet 6 inches and 20 feet 6 inches in height respectively to the existing religious assembly building. The additions are important to the synagogue because it will allow the applicant to also undergo interior alterations to establish a new sanctuary/prayer hall, classrooms, flex spaces, meeting rooms, and restrooms. The applicant plan also maintains 9 on-site parking spaces, which meets the ordinance's off-street parking requirement. In order to permit the project, the applicant is seeking a special use to allow the conversion of the existing building into a 72-seat religious assembly use and a variation to eliminate the 7-foot landscape setback with 1 tree and shrubs along North Francisco Avenue. The hardships in this case are designing functional additions to an existing non-conforming non-residential building located on irregular zoning lot that has 2 street frontages. I have 3 witnesses here available to testify on behalf of the applicant, Michael Steinmetz, our project architect, Yosef, and our MAI land use appraiser, Joe Ryan.
Okay, thank you. So there is a letter of recommendation for the special use, which is for the actual facility, the assembly, religious assembly facility. And it is a letter of the recommendation is for approval. And provided that it is issued solely to the applicant and that the development's consistent with the design included in the application. So is that, do you agree with that?
Yes.
Okay. Are there any questions? Anything that needs clarification? Okay. I move that this matter be approved. Commissioner Soto seconds. Commissioner Gianni?
Yes.
Commissioner Hobbs?
Yes.
Commissioner Staley?
Yes.
Commissioner Soto?
Yes.
I vote yes, the matter is approved.
Thank you.
Thank you very much.
Next case, 21726S, 8235 to 37 West Irving Park Road.
Hmm? Okay, good. Good to know. Morning.
And good afternoon.
Oh, right. I actually acknowledged that already, but I'm wishing it were morning. Okay, can I have the applicant and the witness, raise your right hand. Do you swear that your testimony before us today will be truthful and accurate?
Yes.
And for the applicant, do you swear that the application is submitted continues to be truthful and accurate? And okay, so we have here multiple, well, two different variations and a special use. On the special use, let me just take care of this right now. There is a approval recommended from the Department of Planning, provided that that the design and layout is consistent with what was submitted to us in the application. So do you agree with that? Okay, so, and you are counselor?
Yes,
Can you introduce yourself and your applicant and your witness?
Yes, Your Honor. Again, good afternoon, Chair. Good afternoon, Commissioners. My name is Francis Ostian. I am the attorney for the applicant Sapori Napolitani Pizzeria, Ristorante, and Bar Incorporated. To my right is Evelina Obrecht, who is the owner of the applicant entity. She has 10 years' experience running restaurants. And to my left is Mike Wolin, who is our expert appraiser, who has prepared a report in support of this application. We do have a letter of support from Alderman Sposato, and we do have a letter, as you pointed out, of approval from the zoning staff.
And this is a second location?
Yes.
You're not closing the first, are you?
No, it's closed already, the first one.
Is it?
Yes.
Okay. I didn't know that. It's really cool.
It's too-
Is there a
it's too
change
much.
of ownership? Is there a change of ownership?
For the first location?
Yeah.
No.
Oh, okay. Okay, so any questions here? Yeah, no questions. Therefore, I move that approval of this matter. Commissioner Soto seconds. Where is he? Yes. Commissioner Gianni?
Yes.
Commissioner Hobbs?
Yes.
Commissioner Staley?
Yes.
Commissioner Soto?
Yes.
I vote yes, the matter is approved.
Thank you.
Thank you.
Thank you very much.
The cases 21826S, 21926E, 22026E, 1282 West Washington.
Sorry. Got it. Yeah. This is 3, okay. Morning.
Good morning, afternoon.
Afternoon.
Trying to confuse me.
Okay, can I have the applicant and witnesses raise your right hand? Do you swear that your testimony before us today will be true and accurate?
Yes.
And for the applicant,
Me.
do you swear that the application is submitted continues to be true and accurate?
Yes.
And have you had an opportunity to read the recommendation from the Department of Planning?
Yes.
And do you agree with do you agree with the provisions that they're suggesting that we have you follow?
Yes.
All of them. Okay. I'm not going to read them into the record because it'll be part of the record. It's getting late. For the record.
For the record, I'm hungry.
Okay. I'm sorry, we're getting goofy here. Counselor, can you give us a brief overview
Sure,
and
Uh,
introduce your folks here?
I will. Good afternoon. Rolando Acosta here on behalf of the applicant. With me is Seb Solomon, who is the manager of the applicant. And to his right is Zachary Jacobs, who is the architect for the project. The subject property is on the north side of West Washington. It's a vacant site. The applicant proposes to build a new building on the site, and there's 3 requests connected to the building. I think that building, is it down yet?
Next week.
Next week. Sorry, not vacant yet, soon to be vacant site. So demolition of the existing building for construction of a new building. The issue, there's 3 requests. The first is a special use for ground floor residential. because we have no commercial space on the ground floor. The ground floor of this building is devoted to parking, the lobby, and ancillary spaces. This is a C13 property, so we require a special use to sort of avoid the the commercial on the ground floor. We have residential structures to our west. We have residential structures to our east. We have residential structures to our south. Basically, it's a residential area, so this would continue that pattern. The second request is for a rear yard setback reduction that is really being generated by the fact that on the upper floors, we have balconies projecting from the rear of the building, and they're being held up by columns. So the zoning ordinance would permit balconies to project if they are cantilevered or hung. But once you put in the columns, you need to get a rear yard setback. So that's the second request. The third request, which sounds a little strange, is to increase the front yard setback. So we're on a pedestrian street. Because we're on a pedestrian street, the front of the building has to be no more than 5 feet from the sidewalk. The center of the building meets that, but the two sides of the building actually are set back approximately 12 feet. The reason we did that is we have a historic home to our west, and we're trying to give some space at the front to that home. And we have residential, obviously, to our east, and again, trying to give some space. So the architect set back the corners, projected the front, but on the corners, we don't meet the minimum.
Matching each side.
Yeah, so we're kind of matching each side on the sides, but that violates the pedestrian street rule because we're more than 5 feet from the front setback. We've met with the local Chamber of Commerce, the West Central Association. They are supportive. We're not aware of any objections to this.
Thank you. Is this rental or condo?
Condo.
And is there any affordability?
No.
And do you know what the market is over there?
Strong.
All right. Well, I had wished you would, it is, which is why I asked about affordability.
Yeah, this is being done under the existing zoning, which is
Mhm.
why there's no
Mhm.
affordability. Affordable.
Yeah. Just on my part to make a point, which is that but you do need support, you do need some allowances from the zoning board of appeals, which is related to zoning, in order to be able to do that. So I guess I'm saying this to encourage in the future, or even in this instance, to take that into consideration in terms of perhaps contributing to some extent as you proceed with the needs for a variety of incomes in our city.
I
And
also just want to clarify that that is her personal
Yeah.
opinion, not the position.
No,
of
no,
the
no.
zoning board of
Yeah,
appeals.
exactly. I was just wanted to pass that on as something to be considered because I have an opportunity to say so.
And can I just
Hopefully it'll
I'm-
be amplified. so
comment for a second on that? So another project that Zev is doing, it's very difficult to do affordable units in a for sale product because the financial hit is all up front, right? You got to reduce the
Yeah.
price as opposed to a little every month. And in those cases, they are also for sale. It is required, but he is actually producing affordable for sale condominiums in another area of the city,
Right.
basically Lincoln Park, which is also a strong market. So it's not that he's adverse, it's just the economics of each deal. are
I think
strange.
that's great. And I just like to take every opportunity to encourage that to be done as much as possible by folks that are in this industry, in this business.
I agree.
Yeah, great. And it is my personal view. Okay, thank you. Anything else? Anyone else want to put in their 2 cents? All right, I move that this matter be approved. Commissioner Soto seconds, Commissioner Gianni,
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley, Commissioner Soto.
Yes.
I vote yes, the matter is approved.
Thank you.
Thank you. No, that was good. I thought I was clear, but I'm happy that it did clarify. And also I wasn't staying at the city, I thought I had to do it.
No, I understand. I just wanted to make sure that.
Oh, it actually helped me make my point, amplify it. Short of voting no, which I just did once for purposes of making my point. I found a new way to make. Okay, we're back again. All right. So applicant and witness, raise your right hand. do you swear that your testimony before us will be true and correct?
Yes.
And for the applicant, you're both applicants, you're applicant. Do you swear that the application as submitted continues to be true and correct?
Yes.
Okay, great. Counselor, can you introduce your folks here and then give us a brief overview?
Yes. So to my right is Richard Bailey. He is one of the two owners of the property along with his wife. And to his right is Jason Nudelman. He is the architect for the project. So the Baileys wish to relocate to Chicago from Indiana, which is a good idea for individuals as well as football teams. And
Or either to stay here at least.
or stay here at least, right, exactly. And they've purchased this property, which for a long time had a seriously deteriorated, half demolished, single-family home that was the scourge of the neighborhood. They've bought the property that has been removed. They wish to build a single-family home for their family, including enough space for their extended family to visit.
And we got all the information in the application,
Got it.
so I don't.
Two requests.
Two requests?
I was going to say there was two requests in the
Yes,
application.
we got it. We know what they are.
Okay.
And do we have any questions? And this is a single-family home, you live there?
Well,
Right. I think I drive by it often, actually. I move that we approve this matter. Commissioner Soto seconds, Commissioner Gianni,
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley.
Yes.
Commissioner Soto.
Yes.
I vote yes, the matter is approved. Good luck.
Thank you.
Enjoy your home. This can be. Morning, afternoon. Can I have applicant witnesses raise your right hand? Do you swear that your testimony before us will be true and accurate?
Yes.
Applicant, is that you? Do you swear that your testimony before us today will be true and accurate? No, I'm sorry, yeah, I just asked you that. Do you swear that your application as submitted continues to be true and accurate?
Yes.
Okay, great. And just before we go any further, let me just note that we do have a recommendation approval from the Department of Planning and Development, provided that it's consistent with the design and layout that was submitted with your application. So that'll be made part of the record. But have you read this and do you agree with this?
Yes.
So Counselor, if this, we've read your stuff.
Okay.
It's pretty basic here. You want to establish
Live work unit on the ground floor from long vacant space.
exactly. Are there any questions? No? Okay, then I move that we approve this matter. Make life easier for everybody. And Commissioner Soto seconds, Commissioner Gianni,
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley.
Yes.
Commissioner Soto.
Yes.
I vote yes, the matter is approved.
Thank
Easy peasy, right?
Thank you. Have a good rest of your day and your good weekend. Take care.
Can I raise your right hand for both? Yeah. Do you swear that any testimony before us today will be true and correct? And the applicant,
Both.
both of you? Okay. Do you swear that the application is submitted continues to be true and correct? Okay, great. Can you introduce your guys? And I don't think we need much of an overview. We're going to go
Right.
directly to my colleague over here as soon as you've introduced.
Yes, so this is, I'm Tom Moore, and to my right is,
Oh, I'm sorry. Go ahead. I was thinking it was a different item. It's not special use,
It-
but good.
Jason Grittner and Anthony Scarcella, and they own the home, a home that the yard, it's very, it's not a very deep lot. It's really a long lot instead of a deep lot. And so they're just trying to do a season's room, but because the lot is long instead of deep, it's in the rear yard.
Yeah.
And it's already part of the building, but So they need a rear yard variance, and we're aware of no objection, and we request your support as well.
And we're talking about 6 feet.
Pardon?
We're essentially just talking about 6 feet.
Yes.
Yeah.
Beautiful.
Yeah, nice home. I move, to approve this matter. Commissioner Soto seconds, Commissioner Gianni?
Yes.
Commissioner Hobbs?
Yes.
Commissioner Staley?
Yes.
Commissioner Soto?
Yes.
I vote yes, the matter's approved.
Thanks for your patience.
Thank you very much.
Yeah, right, really. Is everything else special use? Oh. Hmm? Yeah, here. Outdoor parking. Okay, so this is, hi. Can you raise your right hand? Do you swear that your testimony before us today will be true and accurate?
Yes.
And do you swear that the application submitted continues to be true and accurate?
Yes.
Can you give us your name and address?
My name is Jeanette Galarzo. My office is at 325 West Huron.
And this is, okay, so you're here on behalf of the this LLC.
Yes.
And this is, there is, it is a special use, and there is a recommendation from the Department of Planning to approve the non-accessory parking lot, provided that it be issued solely to your organization.
Correct.
And do you agree with that?
Yes.
Okay, fine. I'm not sure if we need much information here because it's all in the record, right? We know what it is. It's a non-accessory.
Counselor, do you at least want to put your name on the
Yeah.
record?
Yeah, I
if
was
there's
going to
anything
ask
else?
if I, thank you. Well, good afternoon. For the record, I'm Timothy Barton of the Law Office of Thomas R. Raines, attorney. And here on behalf of the applicant, Metropolitan LLC. As you know, it's an existing lot. We're just trying to continue that use.
Okay,
This is a new applicant.
okay,
Or
got it.
rather, a new operator.
Right, which is why, because of the, okay, got it. Perfect. All right. Nothing else? I move that we approve this matter. Commissioner Soto seconds, Commissioner Gianni,
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley,
Yes.
Staley, Commissioner Soto.
Yes.
I vote yes, the matter is approved.
Thank you so much.
Thank you. Yes. Yeah, they're all yours. Oh, okay. Really? Where's the public comment?
Thanks, everybody who's left for your patience. I know it's been a long
Yeah.
morning.
What's this? Okay. Good afternoon. Can I have you raise your right hand? Do you swear that your testimony before us today will be true and correct? And do you swear that the application is submitted continues to be true and correct? And for the record, there is a recommendation of recommending approval from the Department of Planning and Development, and that will be made part of the record. And I'm going to pass this over to my colleague over here.
Counselor, do you want to introduce yourself for the record, and then I'm happy to
There you go.
start my questions?
Sure. Rolando Acosta, here on here on behalf of the applicant. We helped her with her paperwork, and I was not anticipating on appearing before you, but noting that they had an objector, she asked me if I would sit in for her, so happy to do so.
Are you, so you're looking to open a hair and nail salon at this location?
Yes.
Are you licensed to perform these services under state law?
Braiding, yes.
Yes. Are you planning on hiring additional employees to support your business?
Yes.
How many are you thinking at full capacity that would you consider hiring?
Starting with 2, but I intend on hiring more.
Okay. Will you confirm that all of your hires as you make them will be properly certified to perform the services that you're asking them to
Yes,
to
I
do
do.
at your business? What are the hours of your operation?
9 to 5.
All 7 days,
No, Tuesday through Saturday.
Tuesday through Saturday. Okay, thank you. I appreciate
You're
it.
welcome.
And I know that we have
I
public
know we have
comment.
some public comments. Is there anything else of the? Okay, so we have, are you both requesting to comment? Ma- No, I understand, but do you both want to speak? Okay, so you have, if you could give state your name and address, and then you'll have 2 minutes for your public comment.
Ivan Ajari, 223 East 31st Street, Chicago, Illinois. I read my statement now.
Yes.
I'm here on behalf of Hafid Hair Design, which is at 223 East 31st Street. Magnolia LLC, I believe, wants to open up another hair salon. We are a hair salon, full service. We've been there for over 16 years. They would be less than 100 feet from us. Well, I know it's a special permit, but it's in clear violation of a B1 commercial district of 1,000 feet. I have not seen anywhere in the city 2 hair salons door to door to each other. Also, in this area, it's on 31st Street, which leads to the expressway and to the drive, McCormick. This is an extremely busy, high-traffic street. We already have an extremely bad parking situation in this area. Prairie Street is residential. All the other streets are residential, condos, houses. 31st Street, we have double parking all day long, from Michigan all the way down to the drive, with Amazon, UPS, FedEx, DoorDash, other deliveries, people, UPS mail. Our clients sometimes have to double park. The business right next to us, Duke's Dog Grooming, who could not be here today, is also very opposed because of the parking situation. It would create a horrendous hardship for for the rest of the businesses on 31st Street in this area. Also, the area is already saturated with hair salons and nail salons. I mean, you can go 2-3 miles any direction and find a nail salon or hair salon. In one block, there's simply no
you
need
need
in
to
this
finish up.
community. Okay. All right.
You can finish your sentence.
Oh, there's simply no need in this community for 2 hair salons to be next door to each other like this. And I just want to say, she can't speak English very well, but her main concern is she has a condo right above where she would be, where this business would be, and she's very concerned about the nail salon fumes penetrating into her condo. Thank you.
Thank you.
I need my phone to translate. I need the phone to translate.
Okay, so
Okay. Oh,
we can give you 2 minutes.
Oh, okay. Thank you so much.
Please state your name.
Oh, my name's Linda. I with my daughter it's a baby. I need to translate.
I'm Linda Mei Liang. Hello, everyone. About 215 E31st first floor. Open a nail shop. I live in 219 E31st Unit 3. My eldest daughter lives in 270 second floor number L and 223 Unit 3 Chris. I do not support 215E to open a nail shop on behalf of the owner of Sanfu. The reason is that its stench affects people's physical health for a long time, which will lead to skin diseases and seriously affect cancer. Opposite is the children's playground. Jerry is the BB campus, and 243E is the BB campus. Environmental pollution seriously affects the residential areas of local residents. Nail shops should be kept away from residential communities. I hope 215E industry thank you for your understanding.
Thank you.
Thank you.
Okay.
Thank you.
Yeah. Do we need to go back there so they can? So I'm going to make a motion, but I just wanted to clarify that competition is not a matter to be considered by the Zoning Board of Appeals in any of these matters. And just for clarity, the ordinance that requires a salon to come before us, if it's within 1,000 feet, was not done and written with the intent and is explicitly not an issue of competition. It had to do with its closeness, proximity to residential areas, and the impact on that related primarily to noise. And so that's really primarily what we consider. Having said that, I would like to move that we approve this matter. And Commissioner Soto seconds, Commissioner Gianni,
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley,
Yes.
Commissioner Soto.
Yes.
I vote yes, the matter is approved.
Thank you. Have a great weekend.
Your hair looks good. No, your hair looks good.
It's just, we're only missing.
I'm the hairstylist, no shade.
Yeah. A cannabis and or an objection to a ruling directly. It was was it the same issue with the cannabis?
You, everybody close to open the.
Yes, we did.
Yes, we approved it.
Thank you. Oh, good.
Well, what you were saying isn't true, but I wasn't going to get into that. Sorry, we're sitting here. You are the applicant,
I am.
correct? Okay, good afternoon. Can you state your name and address?
Erica Nevels, 1675 North Milwaukee.
Okay, great. And this is for a hair salon?
Yeah.
And I'm going to pass this over, huh? Yes. Where are you in first? Forgetting things. I'm going to miss you. Please raise your right hand. Do you swear that your testimony before us will be true and correct?
Yes.
And do you swear that the application submitted continues to be true and correct?
Yes.
And for the record, we do have a letter of recommendation for the salon by the Department of Planning. And that'll be made part of the record. Commissioner Staley, it's all yours.
Good afternoon. I just want to confirm, will you be performing hair and nail services at this location yourself?
Yes, I will.
Are you licensed to do so under state and local law?
I am.
Okay, perfect. Will you be hiring individuals to support your business in
Yes.
addition to yourself? Can you confirm that they will also be licensed in accordance with state law?
Yes, they will.
How many, at maximum capacity, I know you'll probably may ramp up, but at max capacity, how many people are you planning? on hiring?
4, not including myself.
Thank you. And then what are the hours of operation for this location?
10 to 8, Tuesday through Saturday to start.
That is all I've got.
Okay. I move that we approve this, that this matter be approved. Commissioner Soto seconds, Commissioner Gianni.
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley.
Yes.
Commissioner Soto.
Yes.
I vote yes, the matter is approved.
Thank you so much.
Good luck.
Yeah, good luck.
Next case, 23026S, 3650 West Grand.
Sole proprietor. That's commitment. I know, but this is her business. She's gonna be busy. Okay. I think this is it. Nothing. Good afternoon. Sorry for the
Afternoon.
wait.
That's okay. Good
Can-
afternoon.
Can you raise your right hand? Do you swear that your testimony before us today will be true and correct? And are you both applicants?
Just me.
Do you swear that your application is submitted continues to be true and correct?
Just
Great. And we do have a letter of recommendation from the Department of Planning recommending approval, and so that'll be part of the record. And Commissioner Staley will carry on.
I just want to confirm, you're the applicant
Yes.
for this application, and what's your role in this
Her friend slash real estate agent.
Oh, got it. Okay, thank you. I
I'm here
appreciate-
for support.
Okay, got it. So for the applicant, you'll be running a hair and nail salon at this location, that's
Yes.
correct? Are you licensed to perform those services, by the state of Illinois? How many people, will you be hiring additional people to, do hair and nails at your location as well?
I have a... ¿Cuántas estaciones tengo?
No, te vas a contratar.
Just,
You'll have, okay.
yeah. I
Will they
will.
also be licensed, to perform these services?
Yes.
Okay. And then what will the hours of operation be? How long will you be open every day?
Monday to Saturday night to 7 and Sunday night to 3.
Okay, perfect. Thank you. That is all I have for you.
Thank you.
Thank you.
Great. I move that we approve this matter. Commissioner Soto seconds, Commissioner Gianni,
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley.
Yes.
Commissioner Soto.
Yes.
I vote yes, the matter is
Thank you so much.
Thank you. Good luck.
Thank you so much.
Next case, 12526S, 3803 West Roosevelt.
Okay, so you're done with your, that was your last hurrah on.
I know.
Okay. Probably not the last time you overrun me to do something.
We're in it together. For today. And then.
Good afternoon. All right, can I have the witnesses and applicant, raise your right hand. Do you swear that your testimony today will be true and correct?
I do.
And for the applicant, do you swear that your application is submitted continues to be true and correct?
Yes.
Great. And there is a letter of recommendation from the Department of Planning for approval, provided that it applies only to the applicant and is consistent with the plans and drawings of the that have been submitted with the application. So have you read that and you agree
Yes.
with that? Okay, perfect. All right, so Counselor, introduce your guys and a very brief overview.
Perfect. Again, Nick Fatikas for the record from the law offices of Sam Banks. I'm here on behalf of the applicant in this case, Independence Fuel and Mini Mart Incorporated. On behalf of me as the president, Wida Othman, our project architect, Amru Syed, and our land planning consultant, Mr. Kareem Musawir. And Chair, in this case, the applicant actually already operates a 6-pump gas station and accessory retail store at 3803 West Roosevelt Road. The applicant is proposing to renovate and reorganize the station and expand the footprint of the convenience store building. Today, the store contains about 895 square feet of total floor area. Our project would increase that retail footprint to about 1,990 square feet. Special use is required in this case because the retail store expansion exceeds 25% of the existing floor area total. We have this is a larger lot, so we don't have that variation regarding the lot size. The special use is just an expansion of the existing operations. Our team's here to answer any questions you or the commissioners have.
Okay, great.
Yes.
Anything? We don't have anything. I move that I move approval of this matter. Commissioner Soto seconds, Commissioner Gianni.
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley.
Yes.
Commissioner Soto.
Yes.
I vote yes, the matter is approved.
Thank you. And I just wanted to say, Commissioner Staley, this is the last time I'm appearing in front of you. Thank you very much. You were a huge asset on the board, so we really appreciate it. We're going to miss you.
I will miss you guys. I'm really sad to be leaving, to be honest.
Yeah, well, when you're getting lunch at 12:45 next Friday or next month, you'll be all right.
It was rare occasions that we were running so
Yeah,
late,
right.
so honestly, I can't
So much.
complain, but I appreciate you, Counselor.
Last case, 12626Z, 11819 South Harbor.
I forgot what? Oh, okay. Oh, this is the one. This is the one that was. All right. Can I have the applicant and witness raise your right hand? Do you swear that your testimony before us today will be true and correct?
Yes.
And do you swear that the applicant, right?
Yes.
That the application is submitted continues to be true and correct?
Yes.
Okay, great. Thanks.
Okay, for the record, my name is Nicole Patinsky, and I'm an attorney with the law offices of Samuel VP Banks. I'm here today on behalf of the applicant ADR Developers LLC.
Counselor, I meant to say this to you before you started. We've read everything in the record. We know what's there, so you don't need to repeat anything. This is really just a brief overview. But we don't need all the details unless it's something new you want to tell us.
Okay, subject property measures 31 feet wide by 123.7 feet. In this case, our hardship is the depth dimension. It is about 1.3 feet shorter than a standard city size lot. And the applicant is seeking to bring the existing building into compliance. The previous owner started construction of the second story without proper permits.
And this is, do you live in this?
No.
So this is it'll be for rent or for sale when you're done?
Correct.
And this is just an existing building that started to have construction on it. You now have acquired it since then, and you're just trying to bring it into compliance?
Correct.
Okay, perfect. Any other questions?
No, just thank you for your patience being the last one on the agenda
Right.
today. Appreciate,
Plus I
appreciate it and apologies.
And I like your t-shirt, but anyway. Okay, I move that we approve this matter. Commissioner Soto seconds, Commissioner Gianni,
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley.
Yes.
Commissioner Soto.
Yes.
I vote yes, the matter is approved.
All right, thank you.
Thank you.
Okay. I think we need to go into executive session. So motion to go into executive session, Commissioner Soto seconds, Commissioner Gianni.
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley.
Yes.
Commissioner Soto.
Yes.
I vote yes, we're in executive session. Actually had one of these later. All right, I move that we return to open session. Commissioner Soto seconds, Commissioner Gianni,
Yes.
Commissioner Hobbs.
Yes.
Commissioner Staley,
Yes.
Commissioner Soto.
Yes.
I vote yes, we're in open session. All right. I move that, first, in terms of case 185-26-A, on the request on the objection for the testimony of the architect, we deny the objection and will allow that to be included in the record. I move that, to approve 185-26-A, Commissioner Soto seconds, Commissioner,
Affirm the decision of.
thank you. I move to affirm the decision of the Zoning Board of Appeals in okay, wait. I move to affirm the decision of the zoning administrator in matter 185-26-A. Commissioner Soto seconds, Commissioner Gianni,
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley,
Yes.
Commissioner Soto.
Yes.
I vote yes. The decision of the zoning administrator is affirmed. Where's Cicero? I have to read all these into a record, right? Page 7. Oops. I need the day to be over. Okay. I move to approve 149-26-7, 150-26-S, 151-26-Z, and 152-26-S. Commissioner Soto seconds, Commissioner Gianni,
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley,
Yes.
Commissioner Soto.
Yes.
I vote yes, these matters are approved. I move to approve the written decisions containing findings of fact consistent with the votes of the board for the May 15th, 2026 meeting. Commissioner Soto seconds. Commissioner Gianni,
Yes.
Commissioner Hobbs,
Yes.
Commissioner Staley,
Yes.
Commissioner Soto.
Yes.
I vote yes, the minutes are approved. I move to adjourn this meeting. Commissioner Soto seconds, Commissioner Gianni.
Yes.
Oh, wait, Commissioner, before we adjourn, I want to thank Commissioner Staley for her great work on the board. We're going to miss her a great deal. I'm going to especially miss her, especially for all the special stuff she does and reminding me all the time what I'm forgetting, more the proper language as opposed to my very clear lay language. So you'll be missed, but I really appreciate that this is a great opportunity for you and wish you the best of luck.
I appreciate it. I'm so grateful for the board. Thank you, God.
All right. Anyone else before okay. So I move to adjourn the meeting. Commissioner Soto seconds, Commissioner Gianni.
Yes.
Commissioner Hobbs.
Yes.
Commissioner Staley.
For the last time, yes.
Commissioner Soto.
Yes.
I vote yes. We are adjourned.